Well, hi, everyone. Thank you so very much for being here with us today. I'm Jocelyn Samuels. I am the Executive Director of the Williams Institute, and it is such a privilege and a pleasure to be able to introduce the 17th Williams Institute Annual Update. I think I am confident that you will find that we have extraordinary panels this afternoon. We have one that is about to begin on the tensions between religious liberty and civil rights, followed by one about California policies and the ways in which California can both be a model for the work that we need to do to move forward the cause of LGBT equality, and ways in which California still has a ways to go. After that, we will have the finals of our moot court competition. We had the preliminary rounds back in March, and I think you will be blown away by how articulate and committed and passionate the student finalists are about our argument, which is a case that involves a Department of Education reversal of policy on access to restrooms and other sex-segregated facilities. Now, I'm sure none of you could even imagine the Department of Education ever reversing position on anything, so this is an entirely hypothetical problem. But I am going to stop talking so that we can get to our first panel, which I know you will find really compelling. But before I do, I want to introduce the moderator for our first panel, Akeisha Anderson, who is the Daniel H. Renberg Fellow at the Williams Institute. She is a multiple degree holder. She graduated from the University of Alabama Law School. She has a Master's of Public Administration. She has a Certificate of Governance. She has done work at HRC and NCLR, and we are just delighted to have her as part of the Williams family. So thank you very much for being here. Akeisha.
As you all know, in 2015, the LGBT rights community witnessed a huge victory when the Supreme Court issued its historic LGBT marriage equality ruling. Sorry, y'all, I'm nervous. For many of us, that ruling represented hope. Hope that we would now be living in a world in which our lives, love, humanity, and identities would be respected by the law and by our communities. Hope that many of our dreams, perseverance, and past work was not in vain. One thing I'm sure that none of us hoped was that we would find ourselves here 3 years later in a world in which many of our past victories and progress are repeatedly threatened on the state, federal, and local levels. While I acknowledge that this room is likely filled with people of various faiths and backgrounds, I also acknowledge that one of the greatest threats to the LGBT rights movement today is what some consider to be the religious rights. Stated differently, while we have made much progress on the legal front in past years, the fight for LGBT rights is now moving into new terrain, a terrain marked with terms such as religious liberty and religious exemptions. To be clear, this is not terrain that is unique or new. For example, the fight for reproductive rights, the fight for racial integration, and numerous other fights have also been fought on this terrain. But in the United States Congress, in the United States Supreme Court, in state legislatures, as well as state courts, policymakers and lawyers across this nation have found themselves grappling with the question of how do you balance LGBT rights with religious rights? Or worse, policymakers and lawyers across the nation have found themselves grappling with the question of what do you do when LGBT rights and religious rights clash? Which must give way to the other? To be clear, the fight that I'm describing is not a fight between LGBT rights and religion itself, but rather is a fight between those who believe that their religious beliefs should give them a legal justification to circumvent existing and future LGBT inclusive anti-discrimination laws and policies. That is the conversation that has brought us here today. Serving on our panel, we have Christy Mowry, David Codell, Elon Meyer, Jocelyn Samuels, and Ryan Kendall to help us discuss these questions. I hope you guys don't mind, but I'll be trying to channel my inner Oprah today. So the makeup of this panel may be a bit unorthodox. Specifically, I'll be doing many question and answer sessions with each of the panelists to discuss topics such as the Supreme Court's case, Masterpiece Cake Shop versus Colorado Civil Rights Commission, as well as current state and federal policies. Specifically, we'll be talking about how religious rights and LGBT rights are clashing in each of these areas. At the end of each of these sessions, once I'm done talking to the last finalist, there will be room for the audience questions, as well as room to see if anybody on social media has asked any questions. So without further ado, I ask you all to help me welcome our panelists, and we'll get started. Oh, sorry. Speaking first, we have Ryan Kendall, and Ryan will be talking to us about the Masterpiece Cake Shop case. Ryan, before we get into the nuts and bolts of Masterpiece Cake Shop, can you tell us what...
Do you mean me?
I'm sorry. David. David, before we get into the nuts and bolts...
Did I scare you? Were you scared?
Yes.
Sorry.
No
Sorry,
worries.
Ryan. David. Before we get into the nuts and bolts of the Masterpiece Cake Shop case, can you tell us just if there's any, can you tell us about any background information that we should know, anything that has led up to this point?
Absolutely. First, can people hear me? Is this microphone working well? Okay. All right. Well, so the Masterpiece Cake case is a case pending in the United States Supreme Court that concerns the question whether a baker can refuse to make a cake for a same-sex couple's celebration of their marriage. I'll get to that case later, but first, some background points. Well, here's the first background point. It is now the law of the land in the United States of America that same-sex couples can marry in every state of this country and in the District of Columbia and in the territory. So same-sex couples have the right to marry. We also have a long tradition in this country of not discriminating in public accommodations. The public accommodations law that prohibits discrimination includes discrimination based on sex, but it is yet an unanswered question by the United States Supreme Court how that applies to same-sex couples. Let's put that question aside, because the Masterpiece Cake case really concerns some constitutional questions. And the case poses issues that involve both freedom of religion and freedom of speech. Now, on the freedom of religion point, in the mid-1980s, the United States Supreme Court issued an opinion written by Justice Antonin Scalia that said that in general, if a state wants to prohibit an act and somebody claims that their religion entitles them to engage in that act, to do that they have a very tough burden to show that they should be allowed to do something that the law is just generally requiring everyone to do because they have a religious belief that prohibits them from doing it. Okay, so the law set, under Justice Scalia, the law set a very tough bar for someone who wanted to claim that their religion entitled them not to comply with a law. Now, the way that case came to the Supreme Court was that a religious group of Native Americans that used peyote wanted to challenge the prohibition of their use of peyote, and Justice Scalia ruled, no, that's a generally applicable law, and you can't claim a religious exemption from a generally applicable law except under some very strict circumstances, okay? Like that it basically lacked a rational basis. And so that has been the law of the land. And going back even further, as Akeisha alluded to, when our civil rights laws were passed in the 1960s, a lot of the objections to the laws were expressed in terms of religious objections. But Congress passed the laws anyhow, and no one has really ever been able to get away with claiming that they can practice race discrimination based on their religion in their provision of restaurant services or florist services or bakery services. So that's sort of the baseline, okay? So today when these cases are coming forward and people are claiming a religious right not to comply with a generally applicable law, I think it's important to understand that that claim goes against about 50 years of history of non-discrimination law and over 30 years of U.S. Supreme Court precedent that holds that generally applicable laws apply to everyone unless you can show an extremely high showing, okay? So when we encounter arguments today that people are making based under the religion clause, that they're entitled to discriminate, they are asking for radical changes either in U.S. constitutional laws that has been expressed by the Supreme Court in an opinion by Antonin Scalia, who was a very religious man, or a radical change in the last 50 years of our nation's history of anti-discrimination laws. So I think the first thing to keep in mind when you hear these claims, they are not normal within the last half century of our nation's history. Okay, these are radical claims. They want to change the law when they seek the right under their religion to deny services to people. Now, that doesn't in itself decide the question, but I think it's very important to understand that these arguments that people have a right based on their religion to deny services to people on the basis of religion, these are radical claims. This is turning the clock back half a century on what this country has accomplished, on one of the most major things this country has accomplished in the last half century, which is to provide that people can go about their lives and walk into a restaurant, walk into a hotel, walk into a florist store, walk into a cake bakery, and order a product or a service and not be denied service or products based on a personal characteristic. So regardless of how the question ends up getting decided, I think it's important that all of us keep in mind the claims that are being made are not ordinary, they're radical. They're turning back the hands of time. Now, it gets tougher with claims that are based on free speech. So this is where the question gets a little more complicated.
David, I'm going to pause right there. Sorry. Can you parse out, just before you get into the free speech claim, can you parse out the facts and parties of the masterpiece case and kind of go through that just in case there are people in the room who are not familiar with it?
Sure.
Go through that really quick.
Yeah. So this case involves a same-sex couple in Colorado that celebrated their marriage, that got married in another state. At the time that they got married, it was not legal to get married in Colorado, though it, of course, would be today. They got married in another state, and they wanted to hold a celebration in their home state. And they went to a bakery, and the conversation with the baker was a brief one. And that actually has complicated this case to a great degree. Bad facts can make bad law. I think if you were picking on either side or any side or whatever, if you were trying to design a case, this wouldn't be the ideal case, because what happened is they walked in, I believe they knew this baker. This baker doesn't refuse to give them, like, say, generic cupcakes or cookies. But when the baker sat down with them and they told the baker that they wanted a cake to celebrate their marriage, by the way, this wasn't an actual wedding cake. It was a celebration to celebrate a marriage that had happened in another state. The baker said no, because he was religiously opposed to same-sex couples getting married. That conversation was extremely brief. The couple left the store, and that's complicated the case in certain ways that relate to the First Amendment claim.
So can you parse that out a bit as well? Can you explain to the room what the arguments made by both parties were, how we got to the Supreme Court?
Yeah. So let's focus primarily first on the first. This panel is about religion, but I want to just spell out the First Amendment issues because, the free speech issues. The First Amendment includes both free speech and free religion. But let me spell out the free speech issues, which are the primary focus of this case, and then turn around and explain how freedom of religion is also involved here. So the free speech issue is this. The cake maker believes that he is engaged in a product of creating a creative work that requires him to express himself, and the government cannot require him to express himself in any way that he does not want to. And by the way, that basic principle, I think if we all just sat back and thought about it, that basic principle is something we would all agree with, right? The government cannot force you to express something that you don't want to express. The freedom of speech principle protected by the First Amendment has long been recognized to also protect the freedom not to express yourself. Just as you can't be denied the right to say something, you can't be forced to say something. You can't be forced to stand up and say the Pledge of Allegiance if you don't want to. So the argument of the cake maker is, I shouldn't have to design this cake because it is an expressive work of art. The practical problem for the cake maker in this case is that the conversation between the cake maker and the two clients was so brief that the cake maker has no idea what they wanted him to express. For all he knew, all they were going to ask for was a plain white cake. The conversation never got that far. This is a bad First Amendment free speech case because their conversation was so short that it's not like the cake maker said, no, I don't want to say love you guys or whatever. He just said, I don't want to have anything to do with this. So it'll be very interesting if this turns out to be a free speech case, how the court will write it, because basically the interaction between the two sets of parties was so brief that for all the cake maker knew, the couple just wanted a plain, I guess I could say white cake, I'll say pink cake. But at any rate, the cake maker just said, I'm not going to make your cake. Okay. But on the religious issue, for the cake maker to prevail, the cake maker needs to show either that the Supreme Court needs to undo its whole long string of precedent that came from Justice Scalia in the 80s that basically says that generally applicable laws apply to everyone, including with respect to anti-discrimination laws, or they need to come up with some reason why this particular set of facts implicated religious liberty. And Justice Kennedy did, during oral argument, express some concern that there was one comment by one of the Colorado commissioners that didn't seem to respect religious liberty. I think a lot of people are speculating that the court is going to kind of punt this case and send it back to Colorado on the ground that there's a question as to whether this one commissioner adequately respected religious freedom. If that happens, it'll be a case whose meaning we'll have to find out later. I think the most likely outcome here, but I've learned a long time ago not to predict these things, is that we're going to get a free speech ruling that is mixed and that probably leans toward a ruling that, look, there really wasn't, there is no free speech right implicated here because this baker told them he wouldn't make the cake before they even asked him what the cake would look like. I mean, we'll have to see what the court says. I mean, there are other things that might be more difficult, like photography cases, but this particular case, the facts really weren't that developed, and I think it's unfortunate that this case ended up at the United States Supreme Court. I think it would have been better if this issue had been allowed to percolate in the lower courts and other fact scenarios come up, and then finally the Supreme Court could take a case after more people had had a chance to weigh in on this issue.
Thank you for that. We are going to move to Elon now. Elon, still on the topic of Masterpiece Cake Shop, I would like for us to talk a bit about the brief that you filed in response to this case. So can you tell us a bit about your brief and the arguments made within your amicus brief?
Right. So the brief that we filed, which looks like this.
And Elon is prepared to give anyone who asks a signed copy.
A signed copy. Well, actually, I have one signed copy, so there's going to be a competition for that. So our argument actually doesn't have to do with the legal basis for the case, but what the implication of the case is for LGBT people. And the claim that we made, the first claim, is this is not about baking a cake, as far as we're concerned, as far as thinking about the experience of LGBT people in their daily life. It's about something much bigger. And that's, I found also in the Proposition A trial, which both Ryan and I took part in. It's sometimes harder to explain to people in the general population who are not that deeply involved and who are not LGBT themselves, frankly, but some LGBT people as well say, well, what's the big deal? It's just a cake. And I think what we're trying to make the point in this brief is that it's really is a big deal, but not because it's a cake. It's about something much bigger. And what it is about the dignity and health and well-being of LGBT people. So that was kind of the overall point of this brief.
Thank you for that. I know that the brief lays out a lot of the research on minority stress and talks a lot about that. So in case anybody in the audience isn't familiar, can you tell us a bit more about the concept of minority stress?
Yeah. I doubt anybody, well, some people in the audience may have heard of this concept, but I'm sure most people don't. So the term minority stress is a term that I've used to describe the kind of experiences that LGBT people have as a result of prejudice and discrimination. So in this case, being refused service or any kind of accommodation is basically what we would call a prejudice event, an event that was motivated by prejudice or discriminatory event. And the notion of minority stress says that having an event is a stressful experience. Like in stressful literature, we know for research for lasting like the past 60 years that having a negative event in your life, being fired from a job or death of a loved one, those are all really difficult events that people experience because they require a lot of what we call adaptation, a lot of getting used to the change in your life because of what happened in that event. In this case here, the notion of minority stress is that in addition to events that can happen and do happen to everybody, negative, stressful experiences, there are also stressful experiences that happen specifically because of anti-gay, because of homophobia, let's say, because of stigma and prejudice. And we're calling them minority stress because they're directed at this minority group specifically. So while everybody could be fired from a job, only a person who is perceived to be gay, lesbian, or bisexual couldn't be fired from a job because of negative attitudes about LGBT people. So in total, when you look at that, I'm a public health researcher, when we look at the accumulation of events that people have over their lifetime, the LGBT people have more events than straight people because of that extra cause, the extra cause that is due to discrimination because they were LGBT. They could be discriminated against for many other reasons. Maybe they're handicapped, maybe they're a racial ethnic minority. But in addition to all of that, there's a cause that comes from being LGBT that has to do with homophobia or anti-gay discrimination. So that's what the notion of minority stress is. And that was kind of the basis, the research basis for a lot of the work, showing the relationship between prejudice and discrimination and health of LGBT population. And we've showed that there's a strong relationship between those kind of negative events or negative experiences. They're not just big events, it could be smaller events, and it could be just kind of conditions. But there's a relationship between the prejudice, the experience of stress, and health outcomes that LGBT people experience more of.
Can you talk a bit about your thoughts on why it was important to present this minority stress argument to the Supreme Court, particularly what the implications could be, depending on how this case will be decided, what the implications could be on this body of work?
So as I said before, the difficulty in terms of explaining the impact of this is that people will say, well, it's just a cake, so what's the big deal? And therefore, tying it in with this whole area of research, we can learn a lot more about the potential impact of the event. For example, we know from prejudice events and from any events that we can think about them, first of all, as I already said, in terms of the amount of change or adaptation that is required by the person. For example, as I said, being fired from a job is obviously a huge change in your life. For one thing, you're not going to work the next day, which might be fun for a little bit, but but there's like actual tangible changes that you have to deal with. The other one is that you don't get a paycheck, right? So there's a lot of actual tangible experiences that you experience with that. The thing that we know from looking at prejudice-related events, or minority stress, as I've called it, is that in addition to this tangible part that you have to deal with as a result of an event or experience, there are also what I call symbolic experiences. And those are harder to grasp because in this case of a cake, the actual event, the magnitude of the change, may be large or small, I'll talk about it in a minute, but there's also the symbolic meaning that tells to the person, we don't serve gay people here. And that is like a greater insult about the person, about who you are. And especially when we're talking about the wedding cake or anything really related to wedding, it kind of goes to the heart of what it is to be gay, because it's really a relational definition. It says that I'm attracted to, I have a relationship, or I have a spouse who is the same sex. And what this person is telling you by rejecting you is, we don't respect this kind of person, you, and people like you. And so the meaning of this event is much larger than just the need to adjust to the actual experience, as I said, for the tangible implication of it. The change is really, and I think a lot of people may sympathize with that. It kind of ties you back to a whole history of rejection and of disrespect and of discrimination and of just feeling that you're not part of society in the same way. It echoes a certain history that, as we know, is hundreds of years old of this respecting gay relationships and rejecting gay people. So this one little event has a much bigger reverberation that goes beyond that. Now, I just want to say one more point about the actual event, because I said there's the tangible thing of, losing a job, you don't go to work tomorrow, you don't get a paycheck. If you just kind of look at the surface, you would think, well, a wedding cake is not a big deal because you can get a different cake. But if you think about a situation where the Supreme Court actually accepts this argument of the baker, and this is allowed in the United States, in every state and every city. Now you have a situation where you're planning a wedding. Now, I haven't planned a wedding, but I understand that it's very stressful. You have to then begin to first, let's say, screen all the people you want to hire, and you have to say, excuse me, do you accept gay people? Because you can't, let's say, hire a hotel for your honeymoon and show up with a same-sex partner to find out, oh, we don't accept gay people, and it's perfectly legal now. So it is not just a kind of minute experience to change the law in that way that you just have to find a different bakery that will allow you to do it. It changes the whole the commercial environment for gay people, where you can see that it has actual real implications. You have to call more places because some places might reject you. You have to spend more money because you're calling more people. You have to do more work because you're calling more people. And this is just one aspect of that, the calling more people. There could be other elements there. Maybe you'll be charged more money for places that say, well, if you're gay, we're going to let you do it, but it's going to cost you more. I don't know what other kind of tangible explanation. So you have both the tangible, actual damage that is causing and the symbolic message of hate that you are hearing again. And after marriage was allowed in the United States, we all felt a certain elevation of our status to greater equality. I think this is going to be a huge blow to the sense of LGBT people and young people growing up gay as being equal in society. So again, I think the impact is much broader than just having to find a new bakery.
Thank you for that, Ilan, for sharing both the tangible harms and then also some of the deeper harms. But one thing that I know also your brief talked about was some of the health consequences of minority stress. So as a final question, can you kind of speak a bit about that, some of the health consequences?
Right. So part of our argument is not only this kind of description of what happens, both in the reaction to this prejudice, kind of if that in this particular case, what happens if it is allowed as a general rule in society to happen, but also the harm to LGBT people that goes to issues of their health and well-being. And this is an area of research that we now have, I would say, at least 2 decades of research on that has shown a relationship between experiences such negative events that are due to prejudice, again, what I call minority stressors, and very significant health outcomes like depression, anxiety, suicide ideation, suicide behavior like attempts, substance use disorders. We find that in all of these, as well as some physical health outcomes, like asthma being a good example, that LGBT people do worse than the general population, and that a significant amount of this reason why they do worse is because they experience more of those minority stressors. So again, the relationship between stress and health is not something new or unique to LGBT people, but because, as I said before, LGBT people experience more stress, therefore they have more of the negative health impact. Very similar to when we look at smoking and lung cancer. So people who smoke are not the only ones who get lung cancer, but they have more of it because they have more of the risk for this because of the smoking. The same way that stress is a risk for many of those health outcomes. So to the extent that LGBT people have more experiences of stress, therefore they also experience more negative health outcomes and a range of health issues that we've seen to date.
Great, thank you. Jocelyn. So I feel like it's an understatement to say that a lot has changed since your time as Director of the Office of Civil Rights for HHS. And I'm sure that this is also a very frustrating topic for you. But I would love if you could talk a bit about some of the changes that we've seen with HHS since your time there, especially because HHS has been at the forefront of kind of this religious exemption battle so far.
Well, thank you for that question. I would say the sort of overall frame of this panel is what is the appropriate balance between religious liberty and respect for civil rights? And the Supreme Court may or may not answer that question in Masterpiece Cake Shop. It's been teed up for them, but whether they will choose to take it on, I think, as David said, is unclear. But I think this administration has been answering that question across the board in a host of contexts and is clearly putting a thumb on the scale, actually a whole hand on the scale, to prioritize protection of religious liberty interests over civil rights obligations that religious entities would otherwise have. And it is, as Akeisha said, I came to the Williams Institute most recently from heading the Office for Civil Rights at HHS, where one of the things that we did was to make clear that discrimination based on sex stereotyping and gender identity is prohibited in healthcare. And I think that what my former office is now doing is opening a back door to be able to deny health care based on sex stereotyping and gender identity through the lens of religious liberty. So just to step back, there have been two announcements in the course of the last 2 months or so that HHS has made. One is that they have created an entire new office to handle religious liberty claims in healthcare. There are very narrowly drawn laws that in some circumstances that are very specifically defined allow medical providers to opt out of providing certain services. They are largely focused on abortion, sometimes on sterilization. Over the course of the 10 years between enactment of one of these laws and the time I left the department, we had gotten fewer than 10 complaints alleging violations of these laws. Despite that fact, this Department of Health and Human Services has decided to create an entire division to defend the rights of religious entities to deny medical care. This, I think, is a perversion of HHS's traditional mission, which is to expand access to care and reduce barriers to care. But the allegation that the administration is making is that there are many hundreds of religious entities that have been forced against their religious beliefs to provide care that violate what they say are their religious tenets. They also, in February, issued a proposed rule that would vastly expand the authorization for religious entities to deny care. And that's a particularly troubling and potentially damaging development because it is clear that HHS is prioritizing denials of care for religious reasons over the health consequences to vulnerable communities. There are only, the proposed rule is hundreds of pages long, so please do not hold me to it. But in my repeated readings of this, I could find only 2 glancing mentions of the potential harm to patients that could be caused if religious entities are authorized to deny care. But beyond that privileging of religious denials of care, the rule poses a particular threat to the LGBT community because it expands the very narrow authorizations that are in the statutes that relate largely to abortion and sterilization and to particular streams of federal funding and to particular medical entities under particular circumstances. Basically, the Office for Civil Rights has taken a global perspective that expands the universe of entities and individuals who will be able to deny care on religious grounds, that expands what it means to assert a religious objection and says, for example, that religious entities do not even have to provide information about where people could get the service if the religious entity denies it. And perhaps most troubling for our community, also includes suggestions that these statutes authorize denial of care to the LGBT community based on sexual orientation and gender identity. Now, I will say, I'm a lawyer. Cases always depend on their facts. There are interpretations of one of the statutes that OCR is interpreting that could go beyond the context of abortion and sterilization. But that statute is also extremely narrowly confined and does not in any way justify, under any circumstances, wholesale denials of care to people based on their sexual orientation or gender identity. So there is no law on the books in the federal canon that would say a cardiologist can refuse to treat a lesbian for heart problems because the cardiologist disapproves of her sexual orientation for religious reasons. There is nothing in this rule that makes that fundamental point clear. The trans community is at particular risk because a lot of the objections to gender transition care over the course of the last number of years have been couched as based in religious tenets. And so if OCR is extending the authorization to deny care for religious reasons to procedures beyond abortion and sterilization, it seems pretty clear as a practical matter that those seeking gender transition care will bear an enormous cost for that authorization for religious providers. And I would say the final danger from this is not just what the rule says and what it protects, but how people will interpret it. And so providers, hospital personnel, chiropractors, insurance companies, they're not going to parse out the details of whatever is ultimately in this regulation. They are going to come away with the sense that OCR has given them authorization to deny care that they believe conflicts with their religious beliefs. That means that cardiologist may just believe that he or she can deny care to a member of the LGBT community based on a disapproval of that person's sexual orientation or gender identity. So even if OCR would ultimately say, no, that kind of blanket refusal of care is not justified under the law, that's cold comfort to someone who's in cardiac arrest and is denied care when they need it. In addition, I think the real risk of this rule is that individuals will be chilled from seeking care that they need for some of the same reasons that Alon mentioned in talking about people not wanting to call up a hotel and say, I'm getting married and my partner is a same-sex partner. Will you rent us a room? People are not going to want to go to a medical provider and be turned away. And so the greatest likelihood is that they may avoid seeking care that is medically necessary. And I am all about our brief in the Masterpiece Cake Shop case. It's a thing of beauty. You know, the color's nice and it's worded beautifully and it makes incredibly important and compelling arguments. But in this context, we're talking about health care. And we could be talking about, and I know it sounds melodramatic, but life or death consequences for people who are denied care based on a provider's religious views about their sexual orientation or gender identity. So it's a very scary thing. We filed extensive comments on the rule about 3 weeks ago, which laid out both the ways in which we thought that this was invalid as an interpretation of the underlying statutes, and also incorporated a lot of the minority stress arguments that we made in our brief to demonstrate that the harm would not be just in denial of medical care for a particular condition, but all the dignitary harms that Ilan discussed as well.
And then one more question, Jocelyn. I'm curious to know, since we're talking about federal policy, I know that my last question asked you about HHS specifically, but now thinking about federal policy broadly, are these isolated incidents that we've seen with HHS, or are there other ways that the Trump administration has attempted to undermine LGBT rights using religion, possibly?
That is what lawyers would call a leading question, but let me say, the answer is yes. So, I mean, I think that this is not an isolated situation. HHS is sort of the leading edge of the policy determinations that this administration has made to privilege religious liberty over other civil rights. But it started with an executive order that the president issued close to a year ago that made clear that religious liberty should be protected to the maximum extent of the law. That was followed by a memorandum that was issued by Attorney General Sessions, who set out 20 principles that should guide federal agencies in considering claims by religious individuals or entities. And among the things that the Attorney General said was, entities should not have to choose between taking federal money and following their religious beliefs. So even if they take federal funds to provide health services or childcare services or TANF benefits, if provision of those services conflicts with their religious beliefs, those religious beliefs should be honored. It is a sweeping memo that authorizes federal agencies to grant exemptions from civil rights requirements in a host of contexts. So religion is one vehicle through which this administration, I think, has launched assaults on civil rights broadly. They also have taken steps to undermine rights for the LGBT community more directly. And I'm confident that those of you in this room are fully aware of some of those initiatives. For example, the ban on transgender people serving in the military, which was announced by tweet and subsequently implemented by the Pentagon and then put on hold by a court and then resurrected by the president, who seems to be just bent and determined to exclude these patriots from military service. There has been the rescission of protections for trans students in school, and we are talking about some of the most vulnerable young people in the United States who now have no recourse under federal law if they're subject to bullying or assault, if they're not permitted to use restrooms that are consistent with their gender identity, if they are treated adversely in other ways, in terms of being excluded from classes or graded down for the fact that their gender identity does not conform to traditional stereotypes. The administration has gone out of its way to take the position that existing civil rights laws do not protect against discrimination based on sexual orientation or gender identity. As David said, uh-oh, the gong is about to yank me. Okay, I'll talk very fast. I'm from New York. As David said, it's really a subject of current debate what Congress meant when it prohibited discrimination based on sex. In the Obama administration, we took the position that that meant sex stereotyping and gender identity. And therefore, that current law that bans discrimination in employment, in education, in housing, in labor, in healthcare, also covered the LGBT community. This administration has reversed that position and has gone ahead and filed briefs urging courts to reject that position as well. So I think Christy's going to have something more positive to say after me so that you don't have to say
Great.
but thank you.
Christy has a presentation to share on what's been going on the state level.
Hi, everyone. I'm sorry. I don't have good news. I actually have very bad news. I could have maybe done this a little bit differently had I known it would be teed up like that, but I'm actually, I think you're going to come away from what I have to say saying that, you know, what David talked about as far as federal constitutional protections, that's no hurdle at all. Look at what these states are doing. Some states, there's the positive piece. It's not all states. So I want to start by discussing state-level religious freedom statutes and how we've seen these laws change over time to become more protective of religious objectors. So moving from where David talked about to the point that Jocelyn's talking about, where we're privileging religious objections over civil rights. So a number of states have enacted state-level RFRAs that are modeled on the federal RFRA. So the federal RFRA was enacted in 1993 in response to that peyote case that David talked about. So the peyote case came down and Congress came in and said, wait, no, we want to rebalance this. And so what Congress did is they passed the RFRA, which essentially says that the federal government or the government cannot burden religious exercise unless its action is narrowly tailored to further a compelling government interest. So essentially a strict scrutiny test, but also requiring that substantial burden. So again, this ratchets up the standard from what David talked about as being any law, any general law, neutral law of general applicability is fine. Now we see this higher test. So then in the case Bernie versus Flores in 1997, the Supreme Court held that RFRA's application to the states was an unconstitutional use of enforcement power. So this basically meant that if someone thought that their state government had burdened their religious rights, they can't then argue that, oh, well, federal RFRA's there and we're protected. So Congress said, no, you can't do that. So the states started to say, oh, no, we need our own RFRAs. So that's when we see state legislatures begin to enact their own RFRAs modeled on the federal law. And like the federal law, we see these state RFRAs incorporating this sort of test, the substantial burden, and then does the government action, is it narrowly tailored to further a compelling government interest? So to date, 21 states have enacted these state-level RFRAs that look like the federal RFRA. You can see there the states in blue are the states with these laws. So now I want to talk about state-level laws that depart from the structure of the federal RFRA. So these are sometimes called license to discriminate laws. For people who have heard that, often that's used in the media. And often these laws are still discussed in terms of religious liberty, and sometimes they're even labeled RFRAs, but they're actually really quite different. So these laws don't incorporate that sort of balancing test that takes into account both the religious objectors' religious rights, as well as the importance of these general laws that prohibit discrimination and protect the rights and welfare of everybody else. So instead, these laws set forth very particular circumstances in which objectors may act or refuse to act according to their religious beliefs, and then they put a complete shield over the religious objector. They don't say, well, what's the state interest here? Nothing like that. They say, okay, you're doing this? That's fine, go ahead. So let's talk about exactly what types of conduct they protect. So again, these aren't really that broad of laws, but they reach into areas where LGBT people can really be affected. So first, just to go back, this is all the states that have any of one of these sort of license to discriminate laws on the books. So now let's go into the specific types. So there are 7 states that allow child welfare agencies to refuse to serve children and families if doing so conflicts with their religious beliefs. Please note that with the exception of Mississippi's law, which I'm going to talk about in a little greater depth in a bit, these laws aren't LGBT specific. So they don't say, okay, child welfare agency, you can refuse to place a child with a same-sex couple. So keep that in mind, but we'll talk later about when these laws were enacted, and you can decide for yourselves whether you think they were targeted to LGBT people and same-sex couples or not. So then there are 4 states that have enacted legislation that allows medical providers to refuse treatment if doing so violates their religious beliefs. So again, with the exception of the Mississippi law, these statutes are not specific to LGBT people or same-sex couples. And there are 3 states that provide that government officials may refuse to perform marriages based on religious objection. Again, they don't say same-sex couples, but I'll let you make a decision there about what other kind of marriages they're refusing to perform. And finally, there's the Mississippi law. For LGBT people and same-sex couples, this is clearly the worst law on the books. I'm going to talk a little bit about the federal case that challenged the Mississippi law, and so maybe people have heard about it through that. It was a pretty high-profile case. But I want to get into the nuts and bolts about this Mississippi law and talk about why it's so bad. So it's not only very broad, but it also specifically targets LGBT people. So let's start. In terms of breadth, the Mississippi law covers each type of service refusal we just talked about, so medical providers, child welfare agencies, and the government officials. But it goes beyond that and actually says that private entities and individuals can discriminate basically based on their religious beliefs in a wide range of areas, including employment and housing and public accommodations. And second, Mississippi's law, unlike the others we just talked about, explicitly targets LGBT people, specifically same-sex couples and transgender people. So I brought out the key provisions here, and that is directly from the law. So I want you to take a minute to absorb just the animus that we see on the face of this law. Oh, some of you can't see it, so I'm going to read it. So it says that the sincerely held religious beliefs or moral convictions protected by this act are the belief or conviction that marriage is or should be recognized as the union of one man and one woman, sexual relations are properly reserved to such marriage, and male, parentheses man, or female, parentheses woman, refer to an individual's immutable biological sex as objectively determined by anatomy and genetics at the time of birth. So, free to do whatever you want to people that fall into these categories in Mississippi. So, not surprisingly, Mississippi's law was challenged. A case was brought by LGBT plaintiffs claiming that the law violated the Establishment Clause and the Equal Protection Clause of the federal Constitution. The district court in Mississippi held that it likely violated both and granted a preliminary injunction. But the injunction was lifted by the Fifth Circuit, which said that the LGBT plaintiffs in this case did not have standing to bring the case, and so the injunction was lifted and the law remains. So before we move away from state-level RFRAs, I wanted to show you this map to provide a little bit more context to the discussion about the relationship between these laws and LGBT rights by taking a look at when they were enacted. So the blue states are the RFRAs that I talked about that are modeled after the federal RFRA, and the orange are these license to discriminate laws. So you can see there, 1996 was just before that Bernie decision came down saying that RFRA could not be constitutionally applied to the states. And then you see there in 2000 that more states were starting to adopt their own RFRAs in response to that decision. And then the map on the lower left is 2013, which was at the time, of course, the Windsor decision came down. And then we just see a proliferation of these license to discriminate laws after Windsor and Obergefell. So that's the map as of today. And some of those orange states also have the blue laws, but where they have an orange one, I colored it orange. Again, I just want to make the point that I made earlier that even though a lot of these laws are not LGBT specific, this timing suggests it was part of probably anti-marriage backlash and that they are intended to discriminate against LGBT people. So in addition to the state level RFRAs, religious objectors can also find protections in their free speech and free exercise clauses of their state constitutions, as well as, of course, the federal constitution, as the Masterpiece Court demonstrates. So some of these, I want to focus today on the free exercise provisions, again, since this panel is about religion. And some courts have interpreted these state constitutional free exercise provisions to offer the same scope of protections as the federal constitution. So we're going to see those kind of arguments under those interpretations play out much the same way as we'll see in the Masterpiece case. But some courts in some states have interpreted their free exercise provisions in their state constitutions to offer broader protections than what the federal constitution has been read to provide. And so in those states, the courts apply their free exercise clauses more like the RFRAs that we see. So it's ratcheting it up again to that higher standard that's more protective of religious objectors. So I just want to look at a few ways these differing interpretations have played out in some of the cases. But since these cases come up mostly in the context of public accommodations, since they're service refusals, I want to first show you again this map of where we have public accommodations non-discrimination laws on the books that protect LGBT people. So LGBT people are not protected from discrimination in public accommodations in every state. So the states in green are the states that protect either sexual orientation or gender identity in their public accommodations laws. The darker green has both characteristics, and the lighter green, there's two states, for those of you who can't see the difference, it's not showing up very well, it's Wisconsin and New Hampshire. They include sexual orientation in their public accommodations non-discrimination laws, but not gender identity. So this, of course, is important because in the other 29 states, it's perfectly legal to discriminate against LGBT people, and you don't actually need a constitutional defense because you're not going to go to court in the first place. So on to the cases. So I want to mention a few that have gotten a lot of media attention. There might be more out there. Please feel free to bring those up during the Q&A if you want to talk about them. But so here are some examples, two cases where the courts have interpreted those free exercise provisions in the state constitution to offer the same scope of protections as the federal constitution. So we have the Klein case out of Oregon, which was a baker refusing to bake a case. The baker lost. And we have the Gifford case out of New York, where a wedding venue did not want to host a same-sex couple's wedding. The venue lost. And you can see there that they made claims both on their state and federal constitutions, same scope of protection. The analysis was the same. In both cases, the religious objectors lost. And of course, in the Masterpiece case, I believe they also made state constitutional arguments. Again, the same scope of protections offered there. But let's talk a little bit about these few cases where an even stickier issue arises, and one that we'll continue to deal with post-Masterpiece. So this is when, obviously, again, a state court or a court interprets the state constitutional protections for religious free exercise to offer broader protections than the state law. Again, looking more like a RFRA test. So there's one that I know of is Arlene Flowers versus Washington. In this case, it was a florist who didn't want to provide floral arrangements for a same-sex couple's wedding. And the florist raised free speech and free exercise defenses in the federal and state constitutions. In this case, the court said Washington's state constitution provides broader protections than the federal constitution. We're going to apply a RFRA-like test. Again, that's does the law substantially burden religious exercise? And if so, is it narrowly tailored to serve a compelling government interest? So the court went through all that. The court actually assumed that religious exercise was burdened, but then it said, actually, a non-discrimination law is a narrowly tailored law that serves a compelling government interest. So this actually flourished. You can't discriminate. So that's what we see under a RFRA-like test. That's the only case I know of where it's actually been applied that way, a state constitutional protection for free exercise. But I do want to note that in the Elaine photography case out of New Mexico, the photographer did raise a state RFRA claim. So again, one of those state RFRAs modeled after the federal law. And the florist lost there, but the court didn't even reach the issue of RFRA and the non-discrimination law and how they interact, because it decided that RFRA could not be used as a defense in a private suit. Some RFRAs in states are worded a little bit more broadly where they might be able to. So what that means is it could be used as a defense in a suit against a state government, but not in a defense between two private parties. So that's where we stand today, and thank you.
All right, and then as our final panelist, Ryan, I'd like to kind of switch over to you a bit.
Not first, final.
So going back to Masterpiece Cake Shop one more time, Ryan, can you tell us what your thoughts are on the arguments made by the primary parties to that case?
Well, before I do that, I just want to observe real quickly what a different conversation we would be having on these issues had Hillary Clinton won the election. And I think that that's actually rather important, because I think some of our safeguards in this discussion are ultimately going to be found in the political process. And I'll come back to that in a second. First of all, my name is Ryan Kendall. The reason I'm here is because I've been kind of working on these issues in my private life for a while. I was, along with Dr. Meyer, witness in the Prop 8 case. I've helped ban conversion therapy in California, New Jersey, and other places, which is a somewhat related issue, as we have to exempt people from those bans because of First Amendment doctrine concerns. So when I was looking at Masterpiece, I went back through and I looked at the doctrine surrounding both the speech claim and the religious free exercise claim. And I'm sure David will agree in saying that this is not the most fun doctrine that the Supreme Court has given us. It is fractured and a little confused, and the reasons for different decisions shift. And so I don't think there's actually a really good constitutional solution for us here. Personally, I think that the plaintiffs in Masterpiece are going to lose on the free speech claim because the court is going to hold that this is not expressive conduct. I think that's the easiest way for the court to decide the case. We don't have to get into the religious exercise issue, and it gets it off the court's docket. But that doesn't really help us deal with this overall issue of what's going on in these types of religious freedom claims. We're still going to have to deal with this issue. And I think that maybe we've come to a sort of uncomfortable détente, where we're going to have to recognize some religious claims, but hopefully not on anti-discrimination grounds against LGBT people. We're not going to be able to get a constitutional solution that gives us what we want every single time. We're going to have to meet in the middle, and it's going to be a messy and uncomfortable process, but it might just be the best process that we have. And when we're talking about religious objections, one thing I think has been missing from the conversation is that this framing contains within it the idea that it is okay to have a moral objection to LGBT identity. I think that's where we need to be engaging on this discussion. The idea that you can have a moral objection to me as a person or my love or my relationships. We have to engage that argument on the merit and win that argument on the merit. We have to celebrate gay people. We have to celebrate lesbians. We have to celebrate bisexual and transgender people, because ultimately, if we change political culture and popular opinion to be on our side, through the democratic process, the laws will come to be more protective of LGBT people. We will have people at HHS who want to make sure that LGBT people aren't discriminated against because of religious claims, instead of the other way around. I think that we also need to flip the discussion to stigmatize the bias that's going on in some of these claims. You know, one thing we haven't talked about is that it is a truly repulsive thing to make a religious claim that you are allowed to discriminate against someone. To say that I don't have to provide medical care to someone because they're transgender due to my religion is a repulsive thing to say, and we should be able to make that point. Like, that religious claim is awful and false. The idea that LGBT people don't have the same moral worth as other people and our relationships are not the same as other people is likewise false. It doesn't matter if your religion teaches it, and we should be able to engage on that ground. Let's see. So I really think that we need to step outside of the legal framework and think about the actual substantive issues. We need to engage in the political process. We need to advocate for politicians who support our rights, and we need to change the culture so that these things are less reasonable to say, so that courts are more skeptical of religious exemptions. There's no reason we have to have religious exemptions that exclude LGBT people. It's a policy choice that we're making. If we change the politics, we'll change the policies, and I think that's ultimately the way that we're going to protect ourselves and reassure ourselves that things like state-level RFRAs and others contain exemptions for anti-discrimination law and other things.
Great, thank you. Can we give our panelists a round of applause? And so now we have about 20 minutes for audience questions. Are there any questions so far? If not, I have a few. While you guys think of questions, that I'll go ahead and ask some of our panelists.
Can I respond to something that Ryan said? Oh,
Actually, we have an audience question. Yeah, I would love to go ahead. Who had a question? I'm sorry. Yeah. Sure, Jody. Yeah. Thank you.
Great panel. Very exciting discussion. A little depressing, but that's okay. That's what the reception is for later,
That's
right?
what the drink
A question for Christy and for Ryan. First, so I was keeping an eye on your maps, and I was looking at the state of Illinois, my homeland, and I was very disappointed in us that we were orange, but also, great that we were green on public accommodations, right? So you described in the one case how non-discrimination protections were seen to be more favored by the court over a state RFRA. So, but have you seen cases where it has gone the other way? And if that's just going to be up to the individual court to decide which matters more? And then also to Ryan, as a non-lawyer who has not really studied religious exemptions or religious freedom, it has always perplexed me that it seems like courts haven't really ever delved into the sincerity part of sincerely held religious beliefs, in the sense that there seems to be like no test as to what is truly a religious objection. I was raised fundamentalist Christian. I never read in the Bible that thou shalt not bake a cake for a gay couple.
It's not in there.
So, so will the courts ever, or have they ever, gone into the actual religious basis for an objection? And I'll just sit now. Okay.
Yeah, do you want to start, Christy?
Yeah, so Jody, I'm really glad you brought that point up. So I wish I had my slides in front of me so I could tell you exactly which states they are. I don't have a printout of them, but there are actually only 4 states that have those RFRAs as well as a non-discrimination law that protects LGBT people from discrimination in public accommodations. So that's where we're going to see those 2 laws clash. So of course, one was New Mexico we talked about with the Elaine photography case, and you mentioned Illinois. They have a medical provider law. So yeah, it's going to come down to the individual cases. So whatever happens in a state, the state RFRAs do vary a little bit, so it might depend on the particular language that's used in each state RFRA. Again, if it can be used in a private suit, or if there's a state agency that has brought the case on behalf of a private individual where they can be used. So it will depend on that. I will just, this is going a little bit off topic, but if I can just take 1 second to address it. So we recently saw a case where a funeral home had discriminated against a transgender employee, and the employee had brought a case under Title VII, and the funeral home tried to raise a defense based on the federal RFRA, since that's a federal law, and the court actually found there that, again, the non-discrimination law does trump the federal RFRA. So that could be informative to the extent that states are looking to federal law to sort of figure out the scope of their own laws. But yeah, we'll have to see that play out, and perhaps more states come into this intersection if they pass non-discrimination laws that include public accommodations.
Also, I think practically we can statutorily exempt state RFRAs, exempt their application to anti-discrimination laws, which might be a policy strategy we might want to adopt. I'm not a First Amendment scholar, but on your question about the sincerity of religious belief, my understanding is that current Supreme Court doctrine prevents a court from engaging in an inquiry as to how central or important a religious belief is, and that makes sense. Who's to say? And, there's no real way to test sincerity. I mean, I guess if you could show someone was acting in bad faith or lying, perhaps. I too, however, share the experience of growing up in a fundamentalist evangelical Christian family, and religion has certainly inscribed itself on my life. And I think what we need to do is make sure that they don't raise those objections in the first place, because there's nothing Christian about being anti-gay as much as they think there is. Religious arguments have been used throughout history to defend the most abhorrent practices. Christianity was used to defend slavery, to defend white supremacy, to defend segregation, to defend sexism, to defend coverture, a practice by which a man owned his wife. And every time religion has abandoned these uses of itself, it has become more Christ-like, not less.
I will add just one comment, Jody, as well, relate to what Christy and Ryan just said. I will say that a recent Sixth Circuit holding in EOC versus GR Funeral Home really did do, the court there really did do a great analysis of RFRA, and kind of was the first time that I've seen a court actually go into whether or not these religious beliefs should be given enough weight here. So I do recommend that any and everybody read that, because it was a great holding and fun to read. Yes.
I wonder, in all these cases, is there anybody at all arguing that these RFRAs are a violation of the Establishment Clause part of the religious provision in the First Amendment? Because aren't they establishing a religion? And the first counter-argument I can think of is, well, we're not establishing a particular religion. But in this country, it is a particular religion. We all know what it is. It's Christianity.
That's a great question. So yes, that's exactly what the plaintiffs argued in the case in Mississippi. And they said that this...
They get anywhere in Mississippi?
They got somewhere in the district court. The district court said, yes, this is privileging these certain religious beliefs over other religious beliefs or non-religious beliefs, and you can't do that. It's likely a violation of the Establishment Clause.
Was that to a RFRA, or was that to...
Oh, sorry.
Oh, well, you could apply the argument to on the other side of any of these so-called religious freedom kind of thing.
Yeah, that was to their...
I was always taught that we have a right to religion and to freedom from religion.
Yeah, so just to clarify, this wasn't the RFRA as the state RFRA. This was one of these other license to discriminate religious freedom laws. But yeah, they did make the arguments there. But if you want to talk more about general RFRAs, yeah.
Yeah, so there's this fundamental thing that we have in our governmental system and in our Constitution, and it's all wrapped up in one First Amendment. And it's that our First Amendment has two phrases that come into conflict with each other all the time. Our First Amendment guarantees freedom of religion, but no establishment of religion. I once heard former Justice David Souter, who had been on the Supreme Court, after he left the Supreme Court, he gave a speech where he explained that one of the most difficult things to contend with as a justice on the Supreme Court is that our Constitution, and I want to bring this back to a point that you made, Ryan, in a second. Our Constitution contains competing principles. That the freedom of religion and the non-establishment of religion constantly come into clash. Freedom of speech and all sorts of government powers to do A, B, C, D, E, F, G come into clash. And that's why we need courts, and that's why it matters who's on the courts. It is simply not the case that all of the principles that we love and that are spelled out in our Constitution lead to one clear answer in multiple cases. We have conflicting principles. And I was thinking of this point, Ryan, when you made the point about the importance of making it clear that moral objections to LGBT status are not okay. And I think one of the things our movement needs to continue to work on in the law, something that we've accomplished in some states, but not quite on the federal level yet, in constitutional law, is the basic principle that discrimination based on LGBT status is presumed wrong. We have that in California. We got that 10 years ago. May 15th this year will be the 10th anniversary of when the California Supreme Court in the in re marriage cases has ruled, first time any state Supreme Court ever ruled, that a law that discriminates based on sexual orientation is presumed to be unconstitutional. Next month will be 10 years. So that's the first time that any state Supreme Court ever held that. And then after that, numerous other courts have so held. We need to get there under federal law so that this is my very legalistic way of trying to put into the law what you're describing, Ryan, which is that the notion that it's okay for the law to recognize a moral objection to LGBT status is wrong. We've gotten past that in a few states by getting heightened scrutiny, strict scrutiny here. And so that, someone wants to come into court and say that the law protects their right to discriminate against LGBT people just because they have a religious belief, they're going to have a hard time here in California. That's sort of like the legal strategy, but there's also, of course, the political, social, educational strategy to have other people recognize that as well.
I do see you. There was one question before you. Winston, do you mind? Do you still have a question? Okay, great. Thank you.
Can you bring up the Florida slide of Christy?
The first one?
The slide about the Florida law.
The
Mississippi. Thank you.
Is it this one?
The one before. That one?
Okay.
Yeah. I guess this is more addressed to Ryan. In terms of the politics and the emphasis on politics, which I don't fully agree with, I agree partially. One of the things I noticed in the Mississippi law is that it might help us in our arguments to take our own claim that discrimination on the basis of sex, men versus women, that the straightforward garden variety sex discrimination is indeed implicated in any discrimination on the basis of sexual orientation and sexual preferences. That the Mississippi law makes it clear that you can discriminate on the basis of against heterosexual people as well on the basis of whether their marital status. And I think that's something that we should really make sure we focus on enough to remind everyone who's concerned about discrimination against heterosexual as well as lesbian women to realize they have a stake in all the issues that the Williams Institute deals with. And I think that alliance is a really important one to reinforce from time to time and whenever we have a good chance.
Thank you for that comment. All right, go ahead.
Good afternoon. My name is James Wen. My pronouns are he, him, and his. I identify as a transgender man. This is a two-part question. And the first question is, I was wondering how closely are legal representation attorneys working with clergy when developing arguments? I do understand that the Constitution is the basis of the law that's being argued. But prior to the Constitution ever being developed, we had the Quran, we had the Bible, and we had the Torah. And so I was just curious to that point, and if you thought that that would actually help legal representation on the LGBT religious freedom cases. The second part is more just a statement, and wanted to ask your opinion on this. I am also a member of the Episcopal Church. I attend St. John's Episcopal Cathedral. And one of the ways, and this is more speaking to the transgender community, in the Bible, and this is for the Christian faith, if we are held to that Jesus is a man, and we are held to that the church is the bride, and thinking that the bride is gendered female, and we're going to hold ourselves to that. Jesus marries the church. But the truth of the matter is the church, in very simple terms, is made up of men and women. And for those of us that are educated, we know that it is made up of a gender expansive group of people. But keeping things simple, you have Jesus, a man, marrying the bride that they're holding to as being female. Yet, the church is really made up of men and women. So essentially, in my view, Jesus has only married the women in that church. But it actually works the other way. If we hold to that the church, being the bride, must be female, then Jesus is either transgender if he's going to hold all these other people to him in the Christian faith, or once again, only the women are bonded to Jesus. And if you can take that thought, and it's just a thought, and turn it into some wonderful legal argument, I would be so obliged and appreciative. In the Islamic faith, I've done a little bit of studying, looking at the characters. I don't know if they're called characters, so if you are a practicing Muslim, my apologies. But apparently the formation of these characters, if those of you that are Muslim and can read and write in Islam, to look at how the characters have formed, and is women somehow embedded in church, or what is the character for Muhammad? And to look at those things. And I don't know actually enough about the Jewish faith to think about that, but I'm happy to meet with some of you that are of Jewish faith or Jewish clergy, and to have that conversation. Thank you.
I guess I just thank you, and thanks for being here. A comment on your first point. I think that there are religious advocacy groups that promote greater dialogue and understanding and respect for civil rights. And in the civil rights community, there are conversations with those groups that are open to having that dialogue. I have to say, I'm a little pessimistic because I think this is a really intractable problem. What we saw several years ago when the Affordable Care Act was interpreted to require that employers include contraception in the health insurance policies they offered to their employees was that there were adherents of particular religious views who said it would make them too complicit in the conduct even to file an objection with the federal government. The federal government had created a process whereby they could opt out of providing the contraception, and it would be provided through an alternative mechanism so that the religious employers would not have to in any way facilitate the delivery of those contraceptives to their female employees. And there were religious groups that rejected that because they did not want to have to file an objection so that that process could kick into gear. When you have that level of resistance to accommodating a balance between individual rights, civil rights or rights to contraception or abortion, and religious beliefs, it's hard to see how dialogue is possible.
Thank you.
But we have been fortunate that throughout our struggles for equality, there have been plenty of religious groups of all types, going beyond just the three that you've mentioned, many religious groups that have supported us, in addition, atheist groups and humanist groups. And I think the thing that's important is that people from all sorts of backgrounds can ultimately, hopefully, not everyone ever will, but there are all sorts of people from all sorts of backgrounds who can fundamentally understand what it means to be gay, lesbian, bisexual, transgender, heterosexual, queer, whatever. And people have a capacity to understand other types of people, and people have a capacity to rise above or beyond or sideways, however you want to look at it, what they were raised to think. And in our coalition, we have been very fortunate to have people from all sorts of walks of life and backgrounds and religion or religious or non-religious groups join in and kind of understand what it means to be a human being and what sexual orientation means and what gender identity means.
So I was wrong about Christy, but David is bringing the good news.
I do have a comment as well to your first question. As Jocelyn touched on in my introduction, a year ago, I was a law fellow with the Human Rights Campaign, and also I'm from Alabama, so I am from the Bible Belt. So I just say that to say I do know from personal experience that that is something that organizations are working on, LGBT-specific organizations are working on, actually having those conversations with clergy and with religious organizations. There are several LGBT-specific organizations that do actually have specific campaigns designed to kind of do that work of changing hearts and minds of those in church leadership. And a lot of them, all of them that I've worked with, use Williams data as one of their tools, because in a lot of communities that have hostile laws and policies, it's not safe to come out as a member of the LGBT community. And so one thing that is really helpful for advocates in other areas is to be able to use the data that Williams has created about the number of people that identify as LGBT in each of these states as a way to share with these clergy members and et cetera, that there are members of your community that are being hurt by your stance and the way that your stance influences policies and laws. So that work is being done. So if that helps bring a smile to anybody's face. Yeah. And we have time for one more question. Yes.
I'm sorry, I did come here late, but I heard enough. That was completely infuriating. I'm out promoting a film right now called The Trump-Pence Regime Must Go. In the name of humanity, we must refuse a fascist America. A better world is possible. And it's a talk by Bob Avakian, who's a revolutionary communist who's come up with a whole lot of vision for a different kind of society. But one of the things that, I mean, the person they just appointed to the head of the CDC, everybody knows this doctor, military doctor, who actually set up in the 80s, late 80s and 90s, within the military, mandatory searches of people who came out HIV positive, putting them in these horrible, outing them in the military and putting them in essentially camps, you know, where they were living a horrible, horrible situation. And those were the days when people were dying and we needed a Larry Kramer and other people screaming it's a plague and refusing to go along with us. I really agree with the thing around it's a moral thing and we got to reshape society, but there's also a political thing. These guys are not, Pence is a dominionist. They are actually reshaping the law of this country. So the Constitution is going to be the Bible. He's a theocrat. We have people that are populating, like the body snatchers, right? That all of these appointments, and these people are serious. And, you know, we just had a woman come here and speak last night on abortion, and it's, you know, another point of view. You know, all the lies around Planned Parenthood, all of this stuff is just being pushed out there. And it's not just, it's black people, it's immigrants, it's a whole repackaging of our society and the rule of law and truth and science and everything else. I really think couching this and really you guys are just amazing. These laws are outrageous. I mean, you look at that Mississippi law, it is. There was an article, one thing, in the New Yorker that said Texas was going to be the future of the country, right? That's what these people are out to do, is to reshape the entire country. I wish you would speak to that. And I want to encourage everyone to watch this film, too, because it's a very deep analysis of how this came to be.
Well, I just want to sound a note of reassurance real quickly to people, because I know that we're in a very fraught time where there are truly horrible things going on, and we're very afraid of what's going to happen. But at the same time, and I think our anticipatory hostility is well justified, but at the same time, if you look at what's happened in these particular cases, aside from the Mississippi law, a lot of the parade of horribles that has been predicted has not happened. After the Hobby Lobby case, we got a decision that let someone have a LSD spiked tea for their religious beliefs, and which I would be all in favor of for that person, not general consumption. And we have a case under our LUPA that allowed a Muslim man to grow a 1-inch beard, right? Those are both good things, right? We are all concerned about how this doctrine is going to develop and how it is going to be cabined and what's going to happen. But just because we're concerned about that doesn't mean that the worst possible outcome is going to happen. And the way we prevent that from doing it is to recommit to the political process, to not become cynical about what's going on with this administration and the Republican Party, but to fight these battles and to win.
Thank you. And with that, I would like to give our panelists a round of applause. Oh, do you have a comment, Jocelyn?
I just want to note, I think engagement in the political process is extremely important. I want to reiterate, we are a nonpartisan organization.
And I'm speaking for myself.
Thank you.
As one comment before you all start to leave the room, I will say that there's a 10-minute break before the next panel starts. So if you guys can be back in 10 minutes, it would be great. Thank you so much.
I didn't say Democrats.
I'm so sorry.
Yeah.
All right, welcome back, everyone. I think people will start to file in maybe as we just start talking. Yeah, they got real excited with the coffee time. Okay. Welcome back for our second panel. My name is Bianca Wilson. I'm the Rabbi Barbara Zaki Senior Scholar of Public Policy here at the Williams Institute. Very excited to open and moderate this panel that Jody and Joe, I think, have accurately described as the good news panel. Although I think when we end, it might be a little bit more the complicated news, but it's definitely better news than the first panel. So what this panel is really focused on is looking at California as a case example. And I think what I found really interesting listening to the prior panel was looking at the number of states that are actively engaging in anti-LGBT public policy making and activism. And when thinking about several of the projects a lot of the projects that we have going on at the Williams Institute, many of which I'm a part of and have had the opportunity to work with most of the collaborators here on my colleagues here on this panel, was that we realized a lot of our work was centered right here in California. And I'd actually argue, and I think this is something we could come back to in the discussion, but I'd argue that I think that would be the case even if the Williams Institute itself was housed in Illinois or housed in Iowa, that there's a lot of activity here in California and available data that would bring us to doing this type of work. So I don't think the kind of California component of the Williams Institute portfolio is inherently driven by the fact that we're here in California. There's something special about this state, and which came up at the end of the last panel, and that's really what we're here to talk about, highlighting California as a case example of movement in LGBT public policy and law, and then as well the role of empirical research in informing that movement and the opportunities for further use and creation of collection of data to determine the impact of policies in a state that's known to be particularly progressive relative to the rest of the country. And that's really how we've brought together this group of folks that I really look forward to hearing. So we'll give each speaker will have approximately 15 minutes, and we're organizing it that way to make sure that we have lots of discussion time at the end. I'll actually pose a few questions to them, but then we'll open it up for general discussion. So I won't go into great detail of who our panelists are, because you do have the bios in there, our nice lengthy bios of all their amazingness. But I'll just say quickly that who we have here today first is Ayako Miyashita, Assistant Adjunct Professor at UCLA's Luskin School of Public Affairs in the Social Welfare Department, who will be here discussing HIV criminalization. We have Jody Herman, who is a scholar of public policy at the Williams Institute and one of the leaders in facilitating and thinking through research on transgender issues in the country, who will talk about California data related to gender minorities. Kush Cooper, founder and CEO of Kush Cooper and Associates, and kind of all-around child welfare and LGBT issues extraordinaire, who will talk about California as a case in the area of youth in systems, particularly in child welfare. And very excited to have a guest, Joe Michael, legislative manager at Equality California, that will kind of help pull together some of the empirical research and what does that look like, or how's that being used and thought about in the context of California LGBT laws. So with that, I will turn it over to Ayako.
Thank you. Thank you all for being here, and for the Williams for having me. I have this lovely badge that still says staff. I wear it proudly. I call myself someone who's Williams adjacent because I was born of that organization and have since moved forward, but always still a part of the family, it seems. So this particular piece on HIV criminalization really could be presented by a number of people in this room. One is Amira Hazenbush, sitting right in front of me. And of course, our lovely moderator, Bianca Wilson. Also, the person that was really the visionary for looking at these laws to begin with was Brad Sears. So I just want to acknowledge that the reason why we started to focus on this issue in earnest was really Brad's thinking. So HIV today is something that we often start with when we talk about HIV criminalization, because there's a lot that has changed. What you're going to learn is that the laws that were put in place here in California were put in place in 1988 for the most part. 1988 was a time when we didn't yet know a lot that I think we're coming to know. It was also a time when there were no effective treatments for HIV. Some of you may know and understand that what's become big news everywhere is two main things. One is that if a person is living with HIV, they can be on effective treatments that reduces the viral load in their bodies, and that reduction in viral load can go to the point of being undetectable. And that once a person has reached an undetectable viral load and maintained that undetectable viral load, they can no longer transmit HIV to their sexual partner. This is something that is a change, is a shift, and has changed a lot of lives. The other second piece that I would say that has changed the landscape is the biomedical intervention called PrEP. PrEP is the pre-exposure prophylaxis. It's the use of a particular HIV medication that can be used by a person not living with HIV to prevent ever acquiring HIV, up to 100%. If I could just see a show of hands, is this new for anybody in the room? Okay. So I'm glad that the word is out, and I'm glad that everybody in this room is comfortable with that. So as you might have heard lately, the really big news, and I think in the public and that we've been talking about, is the notion of U equals U. Undetectable means untransmittable. And this is news that has gone around the world. When I was looking for little snapshots to pick up for this PowerPoint, I even found one from Vietnam. I didn't add it here, but it was so heartening to see that this is something that's being talked about around the world. So in that landscape, one of the things that sort of comes up is, well, what's stopping us to achieving what Hillary Clinton actually said, moving towards an AIDS-free generation. What is keeping us from that? And one of the things that we study from a social science perspective often is understanding that engagement continuum. If a person is living with HIV, what are the things that get in the way of reaching that undetectable viral load and maintaining that undetectable viral load? And as social scientists, what we've often sort of leaned on to better understand why this is the way that things are is the notion of stigma. So I started this talk by sharing with you that a lot of the laws that were put in place in California were put in place in 1988. They were put in place at a time when there were no effective interventions, as I said, but also they were put in place at a time where even though scientifically we knew how HIV was transmitted, that information was not necessarily shared widely. So we knew how HIV was transmitted, right, through sexual contact. But the fear, and I think as a result of the people that witnessed that first wave of folks that passed, was really the spark that lit the fire that led to these laws being put into place. So what you see here is a table of all the different laws that some of which had in California until January 1st of this year. The main one that a lot of people focus on is that second one in red, the exposure to HIV with intent to transmit. If you think about HIV criminalization laws, the focus often in the public discourse is about situations where there's non-disclosure. Two consenting adults entering into a relationship and in which the person living with HIV does not disclose their HIV status. So in California, that would be that second statute. What we knew in trying to pursue this issue and trying to address these laws that we felt were outdated and informed by stigmatized notions of what is HIV and how do we treat HIV in our society, we knew that we needed to have a good story. And with these laws, we had no story because we didn't have the data. We were able to find a few people that were impacted by these laws, but oftentimes their stories were not clear-cut. They were not easy to tell. And so what we decided to do was to go looking for that data to be able to tell this story. The California Department of Justice maintains a set of data referred to as the Criminal Offender Record Information data. So what we did was we asked them to pull up any kind of data they had relating to these HIV criminalization laws. And these data include everything from arrest all the way to after a person may have been detained and released, right? Or after they've been essentially served their time and left the prison walls. So out of that data, we had 4 main studies that came out. And I think that I've included in here the top highlights for each of those 4 studies, which I don't want to go into too deeply here, but I do want to give you the highlights. So the first study was really an overview of understanding the use of these laws in California. The second study was really looking at the impact on immigrants, because there were immigrants that were impacted by these laws as well. The third study was looking at the evaluation of transmission risk. Okay. Looking at what are the ways in which we look at the risk of actual transmission and whether intent was actually required under these laws. And the fourth was really looking specifically at the criminalization of sex work and looking at people engaged in sex work or people suspected of engaging in sex work. So those are the main 4 studies, and I'm going to share some of you sort of the top lines from that. So who is impacted by these laws? So if you look at the top here across, what you'll see is 4 of the different laws that we have. The solicitation law is referring to solicitation, a person who's living with HIV who's engaged in solicitation. So on the books, we had a law that said that if you were charged and prosecuted for prostitution, we are mandatorily testing you for HIV. if you were found to be living with HIV, the next time you got pulled in for a solicitation charge, we were going to charge you with a felony. Okay. The second is the exposure to HIV with intent. So that's the statute that I talked about earlier. The third is a sentence enhancement for people who were convicted of a sex offense, and they were also living with HIV. I think it's important to note that that non-consensual or sex offense or sentence enhancement does also apply to things like oral copulation, something that perhaps is worthy of looking at because, as we know, oral sex has a very, very low, if negligible risk, according to the CDC, of ever transmitting HIV. And then the last is the misdemeanor. And the misdemeanor is actually a public health law that's been on the books for over 70 years, maybe it's 100 years now. We're getting close somewhere. But that public health law is a misdemeanor charge for any kind of willful exposure that was on the books. And that public health law was used in the instance of HIV. So these are the figures in terms of race. And you'll see that there are some things that stand out. It's made a little obvious by the red circles. When we look at sex, and here's the hard part. I think that Williams has done a really good job of letting it be known that when you don't collect data in a way that actually captures sexual orientation and gender identity, you have problems because you don't know the extent of these forces on the lives of LGBT individuals. So in this case, we have sex with a specific asterisk. This is not gender identity. So we assume that this is sex assigned at birth or the perceived sex of individuals that are interacting with law enforcement. So here, you see that there are definitely different dimensions with regard to sex. With regards to age, we have as young as 14, as old as 71. In charging rates and under the solicitation charge, you should all know that almost all, 98% of the charges that we saw, or the incidents that we saw, were having to do with the solicitation charge, that there were definitely certain trends that we witnessed. So in this, we're looking at those solicitation charges by place of birth. So it's not immigration status, but it's a somewhat of a close proxy. So if you look at this, what you see is a breakdown by place of birth. So looking at that, we know who now, what is the what. 95% of all of these incidents were having to do with me not knowing how to use technology.
Do you need help?
Possibly, yes. How does that look? That doesn't look like anything at all. Yes? Okay. Thank you. We're back to where we need to be. Okay. So we also wanted to look at sort of the demographics of people living with HIV in California and compare those to the people that were criminalized under these laws. So you see here that there are definitely some disparities. I'm being told I'm running out of time, so I'm going to zip through this just a little bit. I'd like to bring some of the message home. The actual outcomes, the sentencing outcomes, you'll see that there are some people that were sentenced to life. Okay. And the averages for these sentences look different for different charges. Obviously, the misdemeanors are the shorter sentences, and the non-consensual sex offenses were the longer. But exposure to with intent and solicitation did lead to years. So we wanted to know, when were these laws used? We see there was a peak somewhere in the middle, right? 2000 would be that peak. And we wanted to know where these laws were being enforced. And guess what, y'all? Los Angeles had the majority of the incidents. second to Sacramento. So when we look at counties, you can tell there, criminal enforcement compared to prevalence rates by county, Los Angeles and Sacramento. And in terms of how these laws are implemented, this is the part that I think always gets me, is that every incident in which a charge was brought resulted in a conviction. 100%. 90% led to sentences of immediate confinement. And of course, that could be a reflection of general trends in the criminal justice system. We see that white men were released and not charged at a greater rate than everybody else. So I think Joe's going to talk about this piece, SB 239, which is the good news part. It's sad I can't be a part of that exactly. But in doing so, if you ever want any reference materials to know what SB 239 entails, I did include them here so that you would know what SB 239 was able to do. So in terms of opportunities, where else can we go from this point forward? I think you all know what I'm going to say. I graduated from the Williams Institute. I learned my lesson. You need to ask. You need to collect data, and you need to ask these questions. It's really about how this research builds into what is a national effort to look at these laws state by state. Amira has continued that charge in looking at data from Georgia. And the other piece of this, and I'm sure that Bianca, when you ask your question, I'm going to come to, is what happens after you pass law? That's the other piece that I'm seeing. People haven't heard about this. People didn't know about it to begin with. And so getting people to care about it and to hear about it and to know what is the law is going to be the next step. So I look forward to talking about it.
Thank you, Afro. Hey, Jody.
Thanks, Ayako. Joe and I might have been a little optimistic. Maybe we should call this the mixed bag panel instead of the actual good news panel. There's a mix. I've got some bad and some good. So today I wanted to talk about a couple of studies that demonstrate the ongoing work that the Williams Institute has been working on in regard to data collection on gender identity and expression, and studies related to gender minority people's health. Our work on this topic has helped move data collection forward on a variety of fronts, particularly for gender minority people and also in regard to sexual orientation. But this movement has been fairly successful, particularly in California, and California has become a leader on issues of gender identity in surveys and in administrative systems, and I'm going to let Joe talk a little bit more about specifics on that later. But that's the good news wrapping for this present. So the research I'm describing today is the result of a multi-year collaboration between the Williams Institute and the UCLA Center for Health Policy Research. The CHPR designs and directs the California Health Interview Survey, or CHIS, as we call it. And it's the largest known resource for data on health and healthcare access in California. It's one of the larger state-level health surveys in the country. So the Williams Institute's collaboration with the CHIS team began in about 2014, which started with the acknowledgement that there was a need for data about gender minorities and that we should test a range of ways that we could identify gender minority adults through the California Health Interview Survey. So this policy brief that you see on the screen is a culmination of several years of testing and implementing new gender identity questions and adding them to CHIS. We also acknowledged that there was a measure of gender expression for youth that has worked well in prior research. So we added this gender expression measure to the CHIS youth survey for those ages 12 to 17. And I'll talk about the findings from those data as well, which we released this report just in December. So after testing and piloting various gender identity measures for the CHIS survey, which included adapting our recommended measures for an interviewer-administered survey, when we put out our best practices report several years ago, the recommendations were based on people filling out their own surveys, self-reporting their information, but we had to adapt them for someone asking these questions over the phone. So the following two-step measure, out of all the ones that we tested, performed best out of the various options and was ultimately used in the CHIS cycle for 2015-2016. They do 2-year cycles of data collection. So the measure has 2 steps. It first asks, on your original birth certificate, was your sex assigned as male or female? And then it asks, do you currently describe yourself as male, female, or transgender? And respondents could also say that they identify with an identity that's not on that list. Using this measure, respondents were identified as transgender if their sex assigned at birth differs from their current gender identity. So those dark squares with the T in them would be where those respondents are classified. And people are identified as cisgender if their sex assigned at birth is the same as their current gender identity, so the gray cells. And I'm getting a call. So using this measure in the 2-year cycle for 2015-2016 CHIS, we estimated that about 0.35% of the California adult population would be classified as transgender using that definition. And that's about 92,000 individuals, and that's adults aged 18 to 70. And we also found demographically, trans adults are more likely to be non-Hispanic white. 46% identified their current gender identity as transgender, and 15% identified with a gender that was not listed in that question. 65% reported being lesbian, gay, or bisexual. 38% have bachelor's degrees, and about a third were living at or below 138% of the federal poverty line. This is just a highlight, we do have some more demographic findings. That report is available online if you want to see all of them. So we looked at many mental and physical health indicators that were available in the CHIS data. And overall, it was somewhat surprising to us. We found that trans adults were very similar to cisgender adults on many measures. But we did find significant differences in a few areas, particularly in regard to suicidal thoughts and behaviors, and particularly suicide attempts, serious psychological distress, and having a disability, where trans adults all had significantly higher proportions on all these measures. There were some fairly stark differences on these measures. For instance, 22% of trans adults had ever attempted suicide in their lifetimes, compared with 4% of cisgender adults. So that's a prevalence of suicide attempts for trans adults that's over 5 times that of cisgender adults. So again, we looked at a lot of different measures and indicators. So if you want to see everything that we looked at, you can find those in the report in our rather lengthy tables. So looking forward, first where we saw differences, we see replication of what has been found in prior studies, that those differences did not surprise us. But there are a few areas, such as in indicators of poverty, where we would have expected differences, but we didn't see them. And so these similarities might reflect that this is actually the truth about the transgender population, that they don't differ on these measures. But it also could be a function of our small sample size, which limited our ability to detect statistical significance. It's more of a mathematical issue. But which is why the next steps will be to continue looking toward additional years of data to strengthen our analysis. We'll be able to have more precise estimates and detect statistical significance if it exists. Also, the current findings suggest that future research endeavors should focus on health disparities and interventions, because the disparities that we did find were certainly alarming. So as I mentioned earlier, in addition to testing and fielding gender identity measures for adults, we were able to include in that same CHIS cycle a measure of gender expression for youth ages 12 to 17. And it's a self-reported measure of what other people think about you, or what you think other people think about you. So the question asks, a person's appearance, style, dress, or the way they walk or talk may affect how people describe them. How do you think other people at school would describe you? And then responses are recorded on a scale from very feminine to very masculine. Youth respondents were labeled as gender nonconforming if they selected the middle option, which we called androgynous, or if they selected the very or mostly options that are different from their reported gender in the survey. So for instance, someone whose gender was recorded as male but endorsed mostly or very feminine responses on this scale. And those respondents, so androgynous is what we call the middle group. The very or mostly respondents, we called them a highly gender nonconforming group. These labels were terrible and lacking, but it's what we were able to come up with for this report. So overall, we estimate that a whopping 27% of California youth ages 12 to 17 would say that their peers view them as gender nonconforming. So over a quarter. And this translates to about 796,000 youth in the state of California. Breaking down that 27%, 6% were in that highly gender nonconforming group, and 21% were in that middle androgynous group. There were no significant differences based on age, gender, or race between these groups. Highly gender nonconforming group reported 55% reported being female. In regard to race and ethnicity, 50% reported being Hispanic. The androgynous group was 63% female and also reported 50% Hispanic. Mean ages ranged from 13.4 to 14.6 across these groups, so it seems to get a little bit older once you get towards the gender nonconforming group, but again, none of these differences were statistically significant. So on the measures that we looked at, particularly in regard to mental and physical health, we found that gender nonconforming youth were really similar to their gender conforming peers, which surprised us in several ways. However, we did find that gender nonconforming youth had a significantly higher prevalence of serious psychological distress in the past year. And that was overall 17% for gender nonconforming youth compared to 7% of gender conforming youth, so about 10 percentage points higher. So some of the findings where no difference was found, including for suicidal thoughts and behaviors, it does differ from prior research on the subject. So if you notice the sample sizes earlier on that table, you would see that for the highly gender nonconforming group, we only had 59 youth in that category. So similar to adults, we looked to additional years of data to strengthen our analyses and provide more precision for those estimates. But psychological distress, was a significant finding, and it's related to minority stressors such as bullying. So future research should aim to reduce minority stress experiences and shore up resilience. And our findings also suggest that we need to increase access to competent and affirming mental health care and various avenues of support, including parents, schools, and community, and increasing support through education. These two reports that I just described are part of a burgeoning area of research on gender identity data collection that Williams has been a part of for a while. And that includes surveys and administrative systems like electronic health records, or even the DMV, your driver's license has a gender marker. Luckily, California has shown itself to be a leader on this issue, especially as evidenced through recent legislation like AB 959 in regard to sexual orientation and gender identity data collection in the state, and SB 179 in regard to gender options that are available in our administrative systems. So I think these pieces of legislation keep us at the forefront on this issue, and certainly other states and even federal agencies are looking to California to learn from us on this issue and see how well these plans can be implemented. There's also percolating the idea that a standard binary gender question that gives people only two options, male or female, on a survey, that these measures are not sufficient, and that other measures, like the two-step measure I described earlier, that those measures actually work well and could potentially replace standard gender binary questions. So we'll see when new developments arise on that front. We have some things percolating at the Williams Institute on that issue as well. And so as measures are adopted across states, we can also look at the impact of positive or negative policy environments. So my colleagues and I have talked about why in these two studies we didn't see differences between gender nonconforming youth and gender conforming youth and trans and cis adults, where we expected to see these differences. And perhaps it's because we're in California, and the positive policy environment in California might be actually having a positive impact on health and well-being, which is it's a wonderful thought. But we definitely need more data, and we need more states to start collecting this data so that we can actually, compare and look. So I look forward to looking into that as more data become available. So that's it from me. I wanted to thank both the individuals and the foundations that have supported these studies, which includes many of you in the audience today. Your donations, for instance, at our Unity events in the past have helped fund all this research, so thank you for that. And here, you probably don't need it, but here's our contact information if you want to discuss this at length. I'm happy to have a call or go for coffee or whatnot. We can talk all about it. All right, and then next we have Kush Cooper.
Thank you, Joni.
Yes.
Good afternoon, everyone. So I'm here to talk to you about a study that Dr. Wilson and I did, and we released the report last year. So we're going to talk about LGBTQ youth preparedness in California, and it's not called LGBTQ youth cultural competency in California. It's called preparedness for a reason. I'll get into that in a minute. So a little bit about how I came to be talking to you today. So we had an organization in Los Angeles a long time ago, 10 years ago, called the Gay and Lesbian Adolescent Social Services, which closed in 2008. I happened to work in the group homes at Glass in my early 20s. And the closure of Glass actually generated a crisis of sorts in Los Angeles County. We didn't know where to send the LGBTQ foster children. We could no longer send them to the Rainbow Island we called Glass. And so the closure of Glass was a blessing and a curse. A curse in that these children got scattered into perhaps non-hospitable placements. But the blessing was that the community had to figure out what to do. We could no longer send them off to the Rainbow Island. Everybody had to figure out what to do with them. We studied, as part of a grant that Dr. Wilson and I worked on, we studied 400 youth that were placed in the Glass group homes from 1998 to 2008. And we saw high levels of involvement both in the foster care system but also in the juvenile justice system. 61% of them had involvement in both systems. They had lengths of stay twice as long in the foster care system as their non-LGBTQ counterparts. They I believe 88% of them displayed emotional or behavioral health concerns. And when a survival analysis was done on the cohort, we found that many of them had actually, contrary to what you think, is that there's sort of sexual orientation or gender identity related conflict in adolescence, and that's why many of these youth come to the attention of the system. Contrary to that, we found that most of them had actually been placed with relatives between the ages of 1 and 4, and then were ending up at the glass group homes. So something was happening in those relatives' homes. And what we know anecdotally is that the children were coming out, and their relatives or their caregivers were calling the system and saying, we didn't sign up for this, please take them from us. So the glass closure also caused the LA LGBT Center to become really interested in now filling the gap that the closure of glass had caused. And we wrote a grant. I was part of the grant writing team in 2010, and the grant, it was a federal grant to reduce barriers to permanency for LGBTQ foster youth. And one of the first things that I did when we got the grant was march the director of Children and Family Services at the center into Brad Sears' office and here at the Williams Institute and said, we're going to do this. We're going to do this grant with the force of data behind us. And so the RISE project is the term for that grant. It was the largest sum of money ever given to an LGBT cause by the federal government. And from 2010 to 2014, I worked on the implementation of the grant, and I think one of the most important things we could say came out of that grant was the LA Foster Youth Survey that Dr. Wilson and I worked on. And what changed everything in the child welfare world is that we finally had a number. We could say that 19.2% of youth aged 12 to 21 in Los Angeles County Department of Children and Family Services identify as LGBTQ. So those of us that have been working in the field for a long time could have told you that. We were seeing it over and over and over. But we finally, this was the first empirical number of its kind, and it really did change the landscape of child welfare and LGBTQ youth. So not only, so if there's 7 to 8% of the general population, 19.2% is almost a 2.5 times overrepresentation. But not only were they overrepresented, there were also significant disparities. We found it. So the LGBTQ youth had more episodes of homelessness. They had more placements on average. They were hospitalized more for emotional reasons. They were overrepresented in the congregate care part of the continuum rather than the home-based care part of the continuum, which means they were in group homes more. They weren't in families. And they more often characterized the county care they received negatively when as compared to their non-LGBTQ counterparts. So this study came to the attention of the Board of Supervisors, particularly District 3, which is headed up by Sheila Kuehl. And in October 2015 came a board motion. And the board motion wanted to essentially figure out how come these children are getting to the Department of Children and Family Services and getting stuck there. What are we missing as a county? What are we missing as a community? So out of that motion came this LGBTQ youth preparedness scan that I proceeded to conduct with Dr. Wilson, and I'll just tell you a little bit about how we went about it. So there's the board motion in October 2015. We spent 2016 doing the data collection, and then the first quarter 2017 we worked on a report. For those of you that do research, that's a pretty aggressive timeline, and I pushed really hard. We got it done. And, it was 11 county departments. So we were asked to look at all the county departments that serve youth in some way, shape, or form. So that's 11 departments. We interviewed 138 managers or directors. And we conducted 443 surveys with more of the frontline staff. And I'll show you a little bit about what we found. You can see some of the numbers, of note, the Department of Children and Family Services, submitted the most surveys. That is not surprising. We were concerned about why the children were getting housed with them. The other sort of frequent flyers, you could say, were the Department of Probation and Health Services. Again, not surprising. Those would be the county departments you would presume have a lot of contact with youth. And the ones that are highlighted in red because there was a subsequent board motion that just got passed in January of this year as a result of this scan, and those departments are now have 90 days to come up with a plan for how to respond to being more prepared to LGBTQ youth. So let's talk a little bit about this notion of preparedness. We chose not to look at cultural competency or cultural sensitivity or cultural humility even. Particularly the notion of cultural competency implies that one can get there. And we're finding that one is never culturally competent, particularly in the space of LGBTQ youth. Things are always changing. We also wanted to move the frame to one of allyship. Like, let's not teach county workers to be competent. Let's have them be allies. And so a framework that worked really well was this framework of preparedness rather than cultural competence. So there are 3 domains we use to assess preparedness: knowledge and comfort, applied experience. So how much knowledge and comfort do your workers have around LGBTQ youth? How much applied experience do they have serving those youth? And then what structural support, such as training or policy, exist to support your direct service with LGBTQ youth? So here's, I won't go through all the data, I'll give you some of the highlights. So knowledge and awareness. One thing we found was that reported knowledge didn't translate to actual knowledge. It doesn't come as a surprise, and I wish we didn't need science to tell people this, but we do. So that's probably my favorite one on this slide. The other thing to note was that we found that paraprofessionals, or the folks that we'd say the folks that don't have master's degrees that are serving the youth, were lacking any basic knowledge, like any LGBTQ 101 knowledge. And the professionals, they had LGBTQ 101 knowledge, but they were lacking in, well, how do I translate that in a practice setting to actually serving these youth? And the other thing we found was staff were using lived experience rather than best practices to actually guide their practice, which can be really, really dangerous, particularly for LGBTQ staff. Presuming that the way it was for oneself when one was growing up is the way it is for a current youth of color in the child welfare system. In terms of comfort and attitude, what I'll say is, actually, this is good news. Folks they reported being really comfortable. So 5 to 10% did not. So we worry about youth that end up accidentally on those folks' caseload. But it was good news for the most part. What we found when attitudes, sort of the same good news, folks were strongly agreeing where they should and strongly disagreeing where they should. But there's this same, as you can see, this sliver over here. 5 to 10% of the workers still think that reparative therapy can help, or that children you should only live with LGBTQ adoptive or foster parents as a last resort. Right. So again, if you're a youth that ends up on the 5 to 10% of workers' caseloads, that's 100% of your experience day to day. Services and experience. One of the interesting ones here is the middle one there. Non-LGBTQ staff thought that their environments were super welcoming. Their LGBT counterpart staff did not think so. I'll skip this one. From a policy perspective, we knew folks could get their arms around non-discriminatory approaches, and they could point to non-discriminatory policies in their own department, particularly aimed at staff. But of the 131 managers we interviewed, only one was actually able to point to one of 8 state policies that exist that would support their work supporting LGBTQ youth. On this slide, I'll point to these two. These, if you got a 45% or a 57%, that would be an F on a test. And so these are particularly concerning. These are the C's and B's and A's above, but people got this wrong, that foster children have a right to know the sexual orientation and gender identity of anyone with whom they share a room. They don't. Social workers are not obligated to disclose the sexual orientation of a foster child to a prospective foster family. We call those resource families now. So there's this general sense of like folks wanting to warn people that they were going to be rooming with, or their child was going to be rooming with an LGBTQ youth. Interesting finding there. In terms of data collection, only 50% of the units said they actually collect demographic information as part of their work, but only 15% collect sexual orientation or gender identity data. And of the folks that said they collected it, it was unclear what the collection mechanism actually was. It couldn't point to a form. Turns out the most common method that we were using to learn about the proportion of LGBTQ youth was self-disclosure. And as many of you can imagine, that's super problematic because there aren't a lot of children in the system with the level of harassment that exists that are raising their hand to say, yes, I'm LGBTQ. So what are some of the implications? We could see that there was this sense of SOGI blindness. So folks were saying, well, we serve all kids the same. We love all kids the same. We're blind. It's just like saying, well, I'm colorblind. So there's a SOGI blindness that at some point training, policy, and coaching is going to have to pierce. Creating preparedness doesn't come out of going to a training. It is a staff development issue. It is training, it's coaching, mentoring, giving folks resources. Folks needed to crosswalk their internal policies. Here, this is really key. Moving away from only targeted LGBTQ service delivery. Like, no, we can't just have the LGBTQ group homes or the LGBTQ clinics. Sometimes some kids won't go to the Rainbow Building for fear of discrimination when they go back home. What were you doing there? And then there's just not enough of those places to manage all the children that need services in the system. We found that departments need to coordinate, that you can't, everybody should collect data the same way, not DCFS collecting it one way and the Department of Public Health collecting it another way. And this, again, like I said before, we have been, the practitioners could tell you all the things we found in the study and the scan over our work with these youth over 30 and 40 years. But what bringing the Williams Institute in on these 2 key studies did was it provided this level of legitimacy that had us be able to go to any forum and say, this is what's going on and we have the science to prove it. And so that has really, really changed the landscape of the of child welfare and the practice we do. And I'll leave it there because I know we're out of time. But we can deal with the rest with questions.
Thank you, Chris.
Good afternoon, everyone.
Good afternoon.
Good afternoon.
Hi. I'm Joe Michael. I work for Equality California. I'm based in Sacramento. I'm really happy to be here with you all today. And what I'm going to attempt to do here is connect all of the amazing research that you just heard about with efforts that are going on legislatively in California to some degree, and to a greater degree, efforts that have already been successful, bills that have already been signed into law, mostly from last year and some from a little bit further back. So let's go ahead and get into that. The first one that I would like to tell you about is very closely related to the presentation that Ayako gave at the beginning about HIV criminalization reform and about HIV in general and how science has changed around HIV and bringing that to the law, right? Making that line up. So that is what SB 239 by Senator Wiener and Assemblymember Gloria to a large degree accomplished. It was a tremendous victory from our view, and we had a great deal of support and help from a lot of organizations that was very necessary to move this bill through the whole process. And what it did was eliminate the HIV-specific criminal laws that IACO described, at least a significant portion of them, and really made it so that people who are living with HIV are not being discouraged from getting tested and seeking treatment if they are having concerns about these laws, as many people did. So that's a really exciting victory, and it was made possible in part through the research that Ayako told you about. This lovely pamphlet here, which I think many of you got copies of, describes the research in a way that frankly made it easy for folks to go through in the context of quick meetings with legislators and their staff. And this went to every meeting that we went to. It went to every legislative office in California and made a really significant impact. And this bill was a challenge to get through the whole process, and there were a lot of moving parts to it. And part of what made it successful was talking about the things that people weren't thinking about in the context of people living with HIV, and particularly in the context of criminalizing living with HIV. And those were the immigration impacts, the 100% conviction rate that Ayako talked about that surprised almost everyone we talked to. The fact that white men were most frequently released and not charged, that also surprised most people that we talked to. They kind of had an idea in their head of who people were who were incarcerated under these laws, and that idea was completely wrong. And it was the research that demonstrated that. We also, I think for the first time, created a video to really explain this whole dynamic to folks in a way that made clear both the science and how the law did not match up to the science, and what the impacts would be for folks if the bill became law. And we distributed that short video to the entire state assembly and got a lot of positive feedback about the impact that that had. So a lot of this was thinking about both the research and what the legislation would do, and also how to really bring that home, how to make it so that when we were talking with staff and legislators, they really understood what the impacts would be. So that's what I'll say about that particular bill. That was one of our great victories from last year. Another that I'd love to talk a little bit about is currently moving through the legislative process, and that's AB 2119 by Assemblymember Todd Gloria. And this is about access to gender-affirming care, health care, all kinds of health care for young people who are in the child welfare system. And this is really very much echoing a lot of what Dr. Cooper was talking about just before, the research on overrepresentation of transgender and gender nonconforming young people in the child welfare system, and that is considering the fact that many are not comfortable revealing themselves. There's still that overrepresentation. And what this bill would do is just make it so that it's as clear as possible under law in California that a young person in the child welfare system can get in the room, so to speak, right? They can get access to a competent healthcare provider, mental health care provider, and can start the process of understanding their gender identity, or continue the process of transitioning if they already identify as transgender. And this is another one of the situations where we're really needing to make clear to folks what this means, who transgender young people are, who gender nonconforming young people are, and what kind of the barriers are to someone's path if they identify in that way, and the support that they need through healthcare interventions to continue on what's going to be a positive path for them and not get derailed into some of the negative impacts that you've heard about before. So, so far this bill has gone through one policy committee hearing. It's still, I guess, early-ish in the legislative process. It doesn't honestly feel that way to me, but it's still fairly early in California. So it's been through that one hearing. we already have a significant amount of opposition that may be in part because of some other legislation that we're working on this year that has kind of rallied folks. And this, unfortunately, is one of the pieces of legislation that they're targeting. So during that hearing, there was a lot of commentary about how best to support young people who are in this position from folks who were opposing the legislation. And a lot of it was just, we just need to love these kids and not do anything. They obviously didn't put it in those words, but that was basically what they were saying, was if we just love them, it'll all be fine. And those were, I would say that was the good part of that testimony. There was a lot that was just completely inaccurate. But, even if we just focus on that, we had to make the case that loving these kids and supporting these kids involves doing something, and explaining what those things are that need to be done, those interventions that are necessary. So we had a young person who is actually currently in the child welfare system testify, and we had a doctor, a provider, testify as well. And there was both, explanation of the background and some of the lay of the land, so to speak, on who these young people are and what they need, and also clearly personal experiences from both the young person and the doctor and provider from their experience in that context. And again, bringing all these pieces together for folks so that it was very clear both that kind of overlay of what the statistics looks like, what the law looks like, and also how this is really going to impact individual people. So that's the takeaway there yet again. I will also talk about SB 179 by Senator Atkins and Senator Weiner, the Gender Recognition Act, as it was called last year. And this one relates to both the research that Jody was describing earlier, and to a great extent, some of the research on how basically all of the issues on non-binary folks and intersex folks demonstrates the health disparities that they experience and the ways those things all interconnect. So a lot of pieces here about why it's important to recognize a non-binary gender identity, and what this piece of legislation accomplished was doing just that, creating a non-binary marker that could be used on any form of state ID, birth certificates, driver's licenses, anything that's state controlled. And again, what we did in order to get to this point was demonstrate that non-binary and intersex people are people who are living in California, are people who, in many cases, were willing to come to the legislature and speak as part of the process of passing the bill, and also talking about what that means on a more scientific level, a data level, and why this recognition is so important. We had a lot of folks come out and share personal stories. We had parents of young people share stories about why it was important to have ID that actually matches who you are for their young people. So all of that was very impactful there. And just the fact that there are these really high numbers of young people who identify as gender nonconforming, indicating that there will be most likely in the future, this is kind of a guess, right? But there will most likely be a greater need than there is right now for a non-binary marker to accurately identify those people and who they are. All right. And this bill is actually from a little while back, but is kind of, and the next bill I'll describe is in this category as well. It sort of goes both ways. There's one side that's talking about how the data is impacting the legislation and making policy change be successful. And this one does that and also goes back the other way because it creates the opportunity to collect more data that's actually collected through the state, and to kind of feed into that further so we can even better develop policy in the future. So that's what these two are all about. And Jody referred to this earlier, AB 959 by Assemblymember David Chu, the LGBT Disparities Reduction Act. This was from 2015 and has had a fairly long implementation time period. And that was because this was really the first piece of legislation that was going to require state departments to start actively collecting data on sexual orientation and gender identity in contexts where they collect other data. There had been no requirement before to do that. So we allowed some time for those departments to ramp that up. And we selected just for departments to start off with. The next bill I'm going to talk about was actually a follow-up bill to this, where we added a number of additional departments who would be required to meet that. So this is the first bill in what will probably be a series over quite a bit of time to hopefully get eventually all areas where the state collects data on demographics, including sexual orientation and gender identity, wherever that other data is collected. And I mean, I think you all have heard really the case for this, right? The importance of this data and the impact that it will have on folks. So I won't go further into that, but I will highlight that this bill includes data on programs like CalWORKs and CalFresh. So we would actually know who the folks are who identify as LGBTQ, who are using those programs, and hopefully at some point down the line, we might be able to put together the degree to which those programs are not reaching LGBTQ people, and perhaps develop how they could serve the community better. So I will move along to that follow-up piece of legislation I mentioned, which is also by Assemblymember David Chu, and this is AB 677 from last year. And what it did was add 7 additional agencies to the requirements under AB 959 to make it so that more data will be coming. And again, there's additional ramp-up time for those departments to actually do all this. But the idea being that we need to continue to expand this data collection, and this included programs like the Commission on Teacher Credentialing to focus on education and young people and trying to improve the recognition of folks in that context, and CalJobs, the Department of Fair Employment and Housing. So there was really a strong focus on education and employment. There's still a lot more to do, particularly in education. There were some parts of the data that's collected that this bill did not fully reach. So there's definitely more to do through possibly legislation in that area, and certainly through implementation. Getting more entities that collect that data on the local level that's not state administered to be pulling that in as well. And again, look forward to future legislation on this issue to try to catch up all of California's data collection here. And I'm hoping that in wrapping this up, this will be, at least to some degree, the good news panel, even though, there's certainly a lot more to do, and there's a lot more that you're hearing that, we will take some thinking about and some challenges that we need to find ways to overcome here in California. But these victories and hopefully victory on the piece of legislation that is still moving through the process, I think are things that we can all be proud of as Californians, and things that can get us excited about what's coming next. So thank you all so much.
Hey, great, thank you. I'm gonna check on the time here, because I want to make sure we have lots of, okay, we have about 20 minutes. So I think what I'm going to do is maybe open it up with one of the questions that I had, and then see what kind of questions and comments you all have, and then if we have time to come back to it, then we can. I mean, one of my most burning questions in my own work with all my colleagues here is kind of, well, what is what do we have to learn from the California case? And just to give a little context, I don't think I've done, one round of kind of press interviews that didn't involve some reporter or some service provider saying something like, well, that's California. Or, well, when we did the foster youth study and identified the 19%, well, that's LA. And, I had to say, okay, well, I hear you, but at the same time, youth don't move into the child welfare system in the same way gay men move to San Francisco. So, there's not, there's still, I could tell that people were grappling with, well, there's just nothing for the rest of us to learn from California. And that's really my question to the panel. My first question is, in terms of thinking about the development of inclusion of SOGI data in both administrative data as well as informing large-scale surveys in the state, in terms of the development of public policies, and I think I just came out of that, but development of LGBT, policies intended to promote LGBT equity or services intended to be better prepared for LGBT youth and adults. Is there something that other states, other jurisdictions have to learn from the California case beyond just kind of throwing their hands up in the air and saying there's something special in their drinking water?
I can go ahead and start on that one. I think definitely there's a lot to be learned from California. And I think other states need to think about where to start, right? And I think there are some other states that are good examples of kind of how to take apart some of the things that have happened in California, split them up into pieces, do them through some other way than the legislature, right? Like if there are, and I'm saying this as someone who does mostly legislative work, but legislation is not always the answer, right? So maybe there's a way to accomplish the same goal in some other way if there's an obstacle that can't be surmounted in that context, right? Being creative, really, looking at what can be taken from some of these things that were probably really big and ambitious and splitting them up. Because if you look at California's earlier legislative efforts, there was a lot that was really incremental, right? Adding to non-discrimination protections piece by piece by piece. So, doing the same thing, doing hopefully some of these things in smaller pieces.
Anyone jump in?
I can talk about it. So, the 1 in 5 number is popping up in child welfare jurisdictions, all across the nation. It's just not Los Angeles. The point we were able to make was, if you ask right, the kids will tell you, right? And that's the thing that we were able to prove. In the foster youth survey, we just called about 3,000 foster children up on the phone. And we asked them all sorts of things, including demographic information, and we made sure that we didn't put the LGBTQ questions in a separate section, right? They were with the demographic questions. And so I think that has given folks a way to know you can ask children that, nothing bad will happen when you ask children about sexual orientation and gender identity, and it has promoted similar kinds of questioning in other jurisdictions.
I'll jump in on that a little bit. My experience has been slightly different from yours, Bianca, but probably because of just the type of work that we're talking about. Yeah, findings out of California might be like, oh, well, that's California. And I can totally see that. But my experience has been like, oh, California, hey, what are you doing over there? So in terms of data collection, the work that we've done with the California Health Interview Survey has been impactful at the federal level. They've, asked colleagues from the Center for Health Policy Research to come and present to the federal interagency working group that's looking at how to incorporate sexual orientation and gender identity measures into federal surveys. The work that we've done with the Trans Pop Project, in which Alon Meyer is the principal investigator. We working with Gallup organization to field sexual orientation and gender identity questions on a very large national survey. That has been influential at the federal level and with other organizations and jurisdictions. And okay, that's the Gallup organization, which is national, but the Williams Institute is at UCLA, so that counts for California, right? And then just a little bit on a more micro level, I was working with the University of California Office of the President on adopting SOGI questions for undergraduate student applications. And we moved forward with a few measures in, I think, the 2016 applications. And they've been flooded with calls from colleges and universities all around the country being like, hey, I see what you're doing over there. How do you do that? And how can we do it? So I do see a lot of inquiries about what is California doing? And since we have these pieces of legislation that Joe was describing, and we're moving forward with it, other states are looking at us to see how we're implementing these various laws and how's it going. Maybe they can hold back for a little bit and say like, all right, let's see how this plays out here for a minute, and if it's successful, then we can adopt it. So it seems like there's a kind of experimental or innovative spirit here in California where we're willing to try things and be the first, and other states can learn from that.
I'm the mixed bag person on this issue. So when we first stepped out to create model legislation, the idea was that California, being such a hospitable state, we could write the law as we would love it to be, and that it would just happen somehow. Joe and Amira and Rick will tell you personal stories about how many different offices we shopped this bill to, and that not a single legislator was interested in taking it. That the landscape was so tough that it wasn't until Equality California, to some degree, found a candidate to back who wasn't even in office yet, that was willing to commit to this bill if he were to be elected. I don't know if that's a secret.
Nice.
It's not anymore.
But it's out. But it's out.
It already wasn't.
I think we're starting to learn that about politics, that sometimes you have to back a candidate to get to the kind of environment you want to have. And so that should say something, that in California, it was so difficult to even find one person, one legislator that was willing to champion the bill. And in California, we had a number of very well-resourced, community-based allies pushing the bill, folks that are seasoned in Sacramento pushing the bill. And I can say from really my heart of hearts, I did not know that this bill would go through until exactly the last moment at which it could go through. So that should say something, that this is a topic that's very hard for people, and that even though we in California did get what we set out to get, that's the good news part. The fact that it was so difficult is really something that's going to ripple through and most likely be true of any other states.
Thank you, everyone. All right, I'm gonna just open it up because we only have 10 minutes. See if anyone has any questions. Feel free to come to one of the mics or just stand up. Probably can hear you.
I have a quick question. You mentioned there are 4 agencies statewide that will have to implement a collection of these 2 major questions. Is there an implementation plan so that they use the same methodology to collect this information, that data? Is there an implementation plan so that all 4 different departments collect the data using the same methodology?
The same way, yeah.
No. I wish there were. And the reason for that, we're trying real hard. And Jody, if you want to speak more to that, please feel free. But yeah, part of the issue is that each of these departments are, well, now there will be more, right, that are not within the California Health and Human Services Agency. But even within the 4 that are, there's a lot of differentiation and federal controls over various parts of things. So there are some things where the federal overlay stops questions being asked or ordered in a certain way. And then there are other parts where the department just wants to do something differently and decides to do something differently, and that has frankly already happened. So I mean, we're gonna have some data that doesn't match up at first, and this is just my view on how the implementation process is going to work out. Right? It's going to be patchy, and we're going to have to put things together for a while, and then hopefully over time, folks will see that they really do need to align all these categories to get data that's actually going to work. So,
and the questions that'll be asked are likely to be different, and the methods and point of contact are not going to be the same. So who asks it in the child welfare departments is not going to be the same thing as who asks it within mental health service agencies. So, yeah, great question. Yes?
Yeah, I can just add, I think part of the reason why that happened is because the biggest issue on this was how much it was going to cost, and the governor's support was based on making sure the departments had flexibility. So we had to make a decision. We actually had some
Right, right.
laws that we knew would not be able to get through, and in fact had been stopped in other legislative cycles because of the cost and because of the lack of flexibility. And so we had to make a decision: is it better to get data, even if we are giving less flexibility, and each of these departments may actually have more say or not get it at all? And that was sort of one of the decisions that we sort of made collectively, and the reason for that.
And on the science end, honestly, whether or not we like it, we now have a series of case studies about how this will roll out, and several of us are looking to try to work with the agencies to kind of track how that goes and how it rolls out. So, sorry, I saw another comment or hand, I thought.
Bianca, can I add something about the implementation piece? So it's a really great question about all of this, right? Like, so what's the implementation plan? When we did the scan, I actually in the report put screenshots of all the other reports over the last, the last 25 reports that my colleagues have written with the same recommendations that I have after we came out the scan, and what was going to prevent this from being the 26th report. And what was going to prevent this from just being the 26th report was, how are we going to do implementation, and how are we going to do implementation well? Just having an implementation plan, I'm also an implementation specialist, and I'm finding that a lot of this policy work actually falls down in the area of implementation. And so I hope we actually see a world where no policy actually becomes the law without some implementation support to go with it. Because a lot of these efforts die on the vine as a result. So it's just a really great question and a really great point.
Yeah, can I just support that? It's, when those of us who have public policy credentials go to public policy school, you study how to create the perfect public policy, right? So in this case, we have done all this science around measurement, and we put together a best practices report, and we, send some recommendations out, and then when it gets out into the field, it's like, the 26 different variables that determine whether or not your questions will be asked and the way they'll be asked. And so it's kind of like you can create a great piece of legislation, you can craft a beautiful public policy, you can craft beautiful survey questions, and then potentially it just all goes to hell. Right? But yeah, so implementation is so key, and I agree that we should pay more attention to it.
How will the two-step approach change at all as people assign gender versus non-binary?
Well, yeah, we've thought about that, but as far as I know, it is not non-binary is not a sex that's assigned at birth. It is something that is an available change to your birth certificate later as an individual. So, but I think Joe can talk a little bit more about this, because I think parents have been requesting to allow their children to be assigned non-binary at birth.
Mm-hmm. Yeah, under SB 179, the bill I spoke about earlier, you can put that on an original birth certificate once that part is fully available, which it should be really, really soon. Technically, it should be already, for an original birth certificate. So that will eventually change over time, and that was mostly for folks who are intersex to be able to be recognized in that way from the beginning and not have to change a birth certificate later. So that surely that will affect how that data is collected later on.
So you're saying, so newborns that have a difference of sex development can have a non-binary gender entered onto their original birth certificate?
In California now, yes.
But for newborns who do not have a difference of sex development, is that option also available?
Yes, there's no
request of the parents.
That was the kind of the justification or intention of why that would be necessary from birth, but there's no requirement or like barrier to entry on having that be on your original birth certificate. It's something that obviously your parents would choose.
Thank you. Yes. Can everybody hear the question? You're welcome to step up to that.
I just want to tie that back to the first panel that had the religious. So if you're at a religious hospital in California and this becomes, and these are on the birth certificates, where the LGBT community or the parents that are open to the LGBT community cannot assign them? Will that be something we run into?
It really shouldn't be. That would be something that would need to be challenged, or would be challengeable, put it that way, because there isn't any like religious exemption or anything in the legislation, and these forms, like birth certificate forms, are all intended to be all the same, regardless of where they come from, right? Wherever someone is born, that birth certificate piece of paper should not be different, except, you know, saying where that happened. But other than that, the forms should all be the same and should be filled out the same way. So that really should not impact what the actual piece of paper ends up saying.
Another question? If not, I have another. So, I mean, this kind of gets to our mixed bag part of the panel, that, you know, despite our California's long list of what would be seen as progressive policies, LGBT inclusive policies, those that would promote equity, we still see in Jody's presentation for our work with CHIS that there are disparities related to mental health for gender minorities, both adults and youth, that's persistent. We see in, you know, our work in the child welfare system that folks feel like they're really comfortable, and yet youth are suffering and are disproportionately both in care and having trouble getting out of the system. And then with our work with IACO, I mean, we see that, you know, not only in the state of California are we dealing with disparities, and kind of also at that intersection, the relevance of racial disparities around who's targeted for HIV criminalization laws. But we see that particularly in LA. So, you know, people often will say, okay, well, it may not be perfect everywhere in California because you have the central, the central part of the state. But in LA, similar to this being one of the most renowned cities with regard to anti-Black police brutality, we also see a heightened kind of response or a heightened level of targeting folks related to HIV criminalization. So I don't know, what is some of that disconnect, that we have this like protective policy state, but we are seeing some outcomes that wouldn't appear to match that in a model that says you change laws, you get great outcomes.
I'll start with that. So what I'm finding more isn't that we have any it's any better here than anywhere else, or any worse here than anywhere else. What I'm finding is that there's a willingness to at least look at the bad news. And that definitely came out in the work we do together, which is, that that overrepresentation and the disparities in the child welfare system. And, there have been books written in all sorts of states about how it is for LGBTQ youth in systems. But it's just, we chose to take our head out of the sand here in Los Angeles, largely, because we had really allies in the legislature. So that's more what I'm seeing.
Interesting.
I would agree with that. In my experience, I moved here from Washington, D.C., which is a whole different thing, and originally from the Midwest. And just broad generalizations in the Midwest, something's different. It's like, ooh. What I was surprised about when I came here to California and started working in some of these initiatives, or with the UCOP or whatnot, is just kind of an openness and an interest that I haven't seen in other places. And so when I talk about like that experimental or innovative spirit, I think that's part of what I'm talking about in California. People are actually at least willing to look at something or have a conversation about a particular topic. But also, just in my experience in implementation in DC, we worked really hard to get in DC a Human Rights Act amended to cover gender identity. And that happened back in 2006. And one of the innovative parts was that all single occupancy restrooms in the district had to be made gender neutral. And so we got the law, we got the regulatory language put out, and it's like, woohoo, and then you wander around the city and none of the single occupancy restrooms are labeled gender neutral. So It's, you know, you can get the law, you can get the regulations, but making the rubber hit the road and making it make a real impact on the ground takes a whole different approach, and we had to do a whole different kind of campaign in order to get it to matter for people's day-to-day lives.
Yeah. Actually, my voice is very loud, so I don't really need a microphone, but I'll use it. What I would say is that we're comfortable in California until we're not. And I'll tell you that I've seen that line drawn in the sand in certain spaces and places that I think might be predictable. One of them is with regard to sex work and the criminalization of sex work and how sex work is policed and who we are criminalizing for that sex work. I think it's not a new thing that people might engage in sexual relations for monetary benefit. I don't think that that's new at all. In fact, they say it's the oldest profession in the book. But in our state, the way that we are using those laws, there are clear disparities, and yet we're not in a place yet where we can even utter the words or think about being in a place where we're no longer criminalizing it from a general perspective. And so even among the groups that were looking at this HIV criminalization topic, there were none that were prepared to take that issue. And I think that conversation is only going to get harder because we've conflated sex work that is voluntary with trafficking, the issue of trafficking. And by conflating those two, you've seen, you know, the conversations happening right now, you've created actually a more dangerous situation for many people. So that's my take on it, is that we're comfortable up to a line, and then there's a line that we just dare not cross. I see it also with regard to HIV generally. We applaud our progress in a lot of ways. We come up with plans for getting to zero, right? Zero new infections and zero stigma. But we know that the trends with regard to HIV are highly disparate when it comes to different races and ethnicities, and also sexual orientation and gender identity. So knowing that, there's a research meeting I went to where somebody said, from a research perspective, as long as we make sure that we serve all the men who have sex with men, we'll get to a place. And the question is that beyond that kind of research perspective of we can get there if that's the only community we hit, is the question of, well, then who's left behind? And so it's really that question that always hits me when I think about, wow, we've really succeeded, and that's really great. But if you're not looking behind you to see who you've left behind, then you really, really don't know the full picture.
Thank you. And I know we're out of time, but Joe, if you have kind of like a 1 to 2 liner to kind of respond to that.
Just going to add real quick that, you know, from looking at Sacramento as kind of a microcosm of the whole state, one of the issues that is constantly coming up is how diverse and how massive California truly is, right? So we see so much variation in people's experiences throughout the state, depending on where they are, who they are, all of that. So I think what's most obvious here is that truly having an impact on the lives of people, regardless of where they are in the state, is going to be a huge undertaking and is going to take a lot of different pieces. And I think, you know, y'all are clearly wanting to have that conversation, and I think that's the first most important step.
Thank you, everybody. Thank you. Okay, so that was great. We have a break now, and please be back in 10 minutes for the beginning of moot court at 4:45. Right? Please stick around. It's always a great, and we're here, right, for moot court? Someone, thank you for asking, Chuck. Moot court is here, yes, so just come back here. Thank you.